Trying to figure out exactly where our posture is on this case, because I've received 2 emergency ex parte motions. You have those, counsel?
No.
Pardon?
No, I received one some time ago for an adjournment that's long since come and gone.
No, these were filed yesterday.
I have no such, I haven't been served with anything. I had no idea those were even in existence.
Well, and I'm trying to figure out, why are they ex parte? Why is the request ex parte?
Permission to speak, Your Honor?
Yeah.
Okay, good morning. They are ex parte because the order that Your Honor signed for $5,000 a month bond escrow, we are trying to revise that to $250,000 refinancing proceeds of another property.
This case is this case currently before the circuit court?
It is currently it's been appealed. Your Honor's judgment has been appealed, and we filed a motion to dismiss the appeal. It's still pending, but that's all I can tell you about that, Judge.
So we'll get copies of these to you, but that's what I mean, I'm not clear I understand these motions, because the first motion is to have a lending institution. You want the bond changed from $5,000 a month, which was the escrow order,
Correct.
to customarily then become your bond on appeal. You want that changed to a $250,000 bond.
Correct. And may I speak the reason?
You can, but I'm not even clear that at this juncture, I would have the jurisdiction to do that. Because I think you would have to request that of the circuit court to change the bond. I've set the bond when the case was before me. It's appealed. That, in my understanding, that's the only thing I can do once the appeal is filed. I can set the bond on appeal.
Likewise,
after that, it's the circuit court. So I don't even know that I can address this. I would also note, counsel, and like I said, we'll get you a copy. There's also this motion to have the R&J Group Holdings pay $250,000
Escrow bond.
for an escrow bond. I don't even know what that, they were the prevailing party, so I'm not even sure how that works. But
yeah, I can't comment on it. I haven't seen any.
I know, and that how these got on. I set this for a hearing on the escrow.
That's what I was under the impression was here today.
I didn't know anything about it. They are not on this document.
For the payment out of the escrow? Is that what I set it for? And I'm not gonna, well, the appeal is still pending, correct?
Correct.
The court set the hearing and I called the court.
Yeah, I
said that they wanted us to come.
sure
So
why did I do that?
When is the hearing?
I must have been under some determination that something had happened with the appeal, but you're telling me it did not.
no, the appeal is pending in the circuit court on this matter.
Okay, then I can't do anything with escrow, so.
May I ask a question, Your Honor?
Sure.
Okay, Mr. Momina's client has made several threats out loud, even in the hallways of this court,
So, ma'am,
to burn the house down. Does the court have authority to issue a PPO against him? I am protecting 4 underage children, my mother on the wheelchair. I don't want him to burn the house because we have a pending case. It's totally out of order.
Your Honor, that's preposterous.
No, it's not.
It's
You even
absolutely,
heard.
I didn't hear anything like that. I
Oh,
don't,
yes,
I've heard,
a lot
I've
of
seen a
people
lot
did.
of things in this case I've never seen before, including ex parte motions seeking a $250,000 bond.
Yeah,
That's
it's a breach of
preposterous.
contract, sir. This is a breach of contract case and a jury demand.
everybody done? No, I can't deal with anything. I have no jurisdiction. The jurisdiction at this point of this case rests with the circuit court.
Yes,
So-
thank
Are
you.
you denying the ex parte motion?
I am,
Or refer.
yes, I'm denying them because they are improperly filed before me. Because I can't do that. You'd have to file those with the
Yes,
circuit.
we'll do that, Your Honor.
All right,
Thank
so,
you.
all right.
Thank you, Your Honor.
Thank you. Here, this is, so that, no, that goes with it, trust me. Then court is stand in recess and give me about 5 minutes and then council come back.
Your Honor, I just want to make it clear, Mr. Campbell and Ms. Rule would like to join us in the back. Is that okay?
Campbell, yes, her, no. No, I'm kidding.
Your Honor, it's the statutory rate. I'm not exactly sure. what the-
I got it.
Five.
Okay, so I'm just telling you, it'll behoove you to pay this the sooner you can, okay, Mr. Daly?
Oh, yes, sir.
All right, understand that this installment payment order, he's gonna present an order to me, I'm going to sign it. Remember, they still could garnish bank accounts and they still could garnish tax returns. Some of them don't at all, some do. But I just want you to be aware of that. So defendant to pay 50 per week beginning September the 3rd. I'm sorry, beginning June the 3rd.
And just, Your Honor, just to confirm, starting June the 3rd and every Monday thereafter.
Correct.
And,
Correct. And the order is
subject-
subject to review on motion of either party on or after October 1.
My payday is actually on a Wednesday. Would it be-
Well, look, you just figure it out. You're gonna get paid this Wednesday and you're gonna get paid next Wednesday and your payment isn't due until the following Monday, okay?
Okay.
I mean,
All
Your Honor,
right.
I have no objection if he wants the payments to be on some day every week other than Monday. That's fine.
You guys figure it out. What do you
Okay.
want, Mr. Daly? It doesn't matter to me. I mean,
Oh, well, I was just hoping that, I could still have my boss do direct payments to them.
you're set up for that, right, Mr. Dresden?
Your Honor, we at this point strictly have a judgment. I don't believe anything else has been done. So there's been no garnishment, as I recall, in this
There's a
case yet.
garnishment
So
order.
if his employer can do that, we are happy to work with them.
Yeah, so you get a hold of Mr. Dresden and you guys figure it out, okay? Otherwise, you have to send a check that gets there on June 3rd or before June 3rd, and then on or before June the 10th and 17th, and so on and so forth. Okay?
Your
All
Honor,
right.
Your Honor, could the court put us back in a breakout room? Maybe I can get these details resolved with Mr.
Sure. Put them in the breakout room, Jennifer, please.
No problem. And Judge, there is a garnishment that was entered 12/23 of 24.
Oh,
So
I'm sorry, Your Honor.
He does have a wage garn.
Okay, so you're gonna suspend that. You're gonna put that in the order too, right, Mr. Dresden?
Yes.
Thank you. Have a good day.
Thank you, Your Honor.
Is Virginia Swindle here?
She has not checked in. And Judge, if I may, I have someone with a Samsung. need her
Folks,
name.
You gotta put your names on the phones. I think our instructions are pretty clear. We can't tell who Samsung is. You gotta tell us your name, ma'am, in the green top, it looks like. Thank you. You have to unmute and tell us your name.
Hi, I'm Christy Horner. I'm sorry about that.
That's okay.
And then I also have someone that's on the screen, a Zoom user I need.
Zoom user, you gotta let us know your name.
Yes, my name is Philip Pettigrew.
Thank you, sir.
What time is the show cause scheduled?
That was scheduled for 8:30.
It's 9:02. Plaintiff failed to appear and defend. You know what? I'm gonna hold this one a minute. Bank of America versus Tara Hazy. Tara Lee Hazy, 2500721.
Good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722. How are you?
Good morning. Ms. Hazy, you have to start your video, please. Tell me your name.
Tara Hazy.
All right. This is just a regular account stated, right?
That's correct, Judge. This is a date and time set for pretrial. I had a chance to discuss this matter with the defendant. She's working with a debt settlement company. We just need a little bit of time. I don't know if the court needs to do a scheduling order or if we could just get a new date maybe in 30 days. Hopefully we'll have it resolved.
Is the debt settlement company talking to you?
Yes, we have spoken with them. Yes.
So you want me to just reschedule this a month out for a pretrial?
I think that'd probably be a good idea, Judge. Yes.
All right, I'll do that. I'll adjourn the pretrial. Lisa, Jennifer.
Judge, you're fine. July 15th or the
Oh, geez,
29th.
For that long. I don't have anything in June.
Well, we have June 17th.
June 17th at what time?
9.
At 9 a.m. June 17th at 9 a.m. Okay? So
Sound good.
I'll adjourn the pretrial until then. Thank you all very much. Have a good day, ma'am, sir.
Thank you.
Synchrony Bank versus Deborah Bishop, 2500895.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
All right, good morning, Mr. Kuipers. Where is Ms. Bishop or her lawyer?
She has not appeared.
Your Honor, just so the court's aware, this account's been paid in full. I was going to ask permission from defendant or defendant's counsel to sign their name on a stipulation to dismiss. So we're in the process of getting that filed with the court.
They answered the complaint, so technically you need a stip in order.
Correct.
You want me just to adjourn it a week and you can call her?
Yes, please.
Account paid. I'll just indicate account paid. Attorney will submit stip in order to dismiss. Well, give me a date in about a week, Jennifer.
Judge, with the holiday, we'll do June 3rd.
Jeez. I don't have anything next week.
Well, the holiday is Monday. I mean, unless you want to do it on Thursday, the 29th at 1 o'clock with our landlord tenants.
Yeah.
Okay.
Let's do that. What day you want? May 29th?
Yep.
May 29th at what time? 8:30. Okay. May 29th at 8:30. Hopefully you'll submit your stip in order before then.
Thank you, Judge.
Have a good day.
You as well.
Citibank versus Lori Sherrill, 2500934.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of Plaintiff Citibank.
Good morning, Mr. Groen. Do I have Lori Sherrill here anywhere?
She has not appeared, Your Honor.
All right, I'm gonna let you take a default.
Good enough, Your Honor. Do you need you want me to put on the record the amounts?
I do.
The charge-off balance was $6,886.88. We've incurred $130.30 in court costs, comprised of a $75 filing fee and a service fee of $55.30. So a total judgment of $7,017.18.
Good enough. Defendant failed to appear This was scheduled for 8:30. It's now 9:05. Default judgment will enter in favor of the plaintiff and against the defendant, 701718. Please submit that today if you can. Thank you very much.
Thank you, Your Honor.
Have a good day.
You too.
What else do I have down there? This thing is driving me crazy. Can I show you something? When you get a minute. Okay. We have anything else?
Hey, good morning, Judge. I'm running on my case on Midland versus Tiffany Jin.
Okay.
Yeah, it's part of the 9 o'clocks, Judge. I think Tabitha was working on getting those.
Your Honor, we're also ready on Capital One versus Janet Bauer, whenever the court's ready.
Thank you. Thank you. No. Discover Bank versus Janet Bauer, 2404185. Appearances, please.
Yes, good morning, Your Honor. For the record, William Saloon, P41487, appearing on behalf of plaintiff. I think it's actually Capital One versus Janet Bauer.
What did I say? It looks like Discover Bank.
It's Discover.
You're correct. It's a successor. Yeah, that's correct, Judge.
Okay. All right. Is Janet Bauer here? Yes, you are. Your name, ma'am?
Janet Bauer.
All right. Did you file an answer to the complaint in this case, ma'am?
I did.
Do you dispute the debt?
Not at all.
Actually, Your Honor, we have an agreement. I'm sorry. I should have indicated that.
That's all right. Go ahead.
Defendant agrees to a consent judgment in the amount of $5,583.07 with $178 court costs. Total judgment amount of $5,761.07. She agrees to pay it in monthly payments of $155.09, beginning June 14th, 2025, with each payment due by the 14th of the month.
All right. I just want to make sure I have this correct. There's going to be a consent judgment, 576107. And she's going to pay that at the rate of $155.09 per month, beginning on June the 14th and the 14th of every month thereafter until paid, correct?
That is correct, Your Honor.
Ma'am, do you understand that?
Yes, sir.
Do you agree to those terms?
Yes, sir.
So long as you make those payments as agreed upon, they cannot garnish your wages. They still could garnish if they wanted to, bank accounts, tax returns, but so long as you make those payments, they're unable to garnish your wages. Do you understand that?
Yes, sir.
And do you agree to these terms?
Yes, sir.
And does Mr. Saloom have your permission to sign your name to that proposed consent judgment, setting forth these terms on that proposed judgment that I will sign?
Yes, sir.
All right. Anything else, Mr. Saloom?
No, Your Honor. We'll get that to the court as soon as possible.
Thank you very much. Midland Credit.
Thank you.
Luck, ma'am. Best of luck. Midland Credit versus
Thank you, sir.
Jin, 2404225. Is music in here? There you are, ma'am. Your name?
Good morning, Judge. Andrew Perry, P69402 on behalf of plaintiff.
Ma'am, your name?
Good morning. I'm Tiffany again.
Good morning. So today is the date scheduled for a pretrial. Did you two talk about this at all, Mr. Perry?
Judge, I offered to discuss the issues with Miss Jim, but she wanted to see you. She didn't want to talk about the case.
Okay. Let's see here.
We filed suit to collect on her credit card account, originating with Web Bank. It's alleged that she owes $584.34.
Do you agree that you owe that amount, ma'am?
Your Honor, I respectfully request that the case be dismissed. I did file a response to this case, and they haven't provided me any type of burden of proof.
Well, I don't know what you mean by that. You filed an answer. Why would I dismiss the case? You don't think you owe any of this money?
They failed to meet the burden of proof. I have not seen a wet
All right,
signature.
okay, all right. Now, wait a second. This is just a pretrial. They don't have to prove anything today.
Okay.
All right? I'm just asking you, listen, I mean, I don't have a problem if you want to make this, you know, you want to go to trial. I have no problem with that. Sometimes, you can make life a little easier on yourself. If you agree that you owe the debt, maybe you can get him to conditionally dismiss the case subject to you paying a certain portion, you know, weekly, monthly, or maybe
I
he'll-
just request that he provide me with full proof of ownership of this account. I haven't got any wet signature, any electronic agreement or anything. All he's showing me are statements.
Judge, perhaps we can get a discovery order so we can exchange some more information. Attached to our complaint, though, was a copy of the assignment showing the transfer from WebBank to Midland, as well as the billing records. So it looks like we might need some more time to exchange information. I'm not really sure what she's talking about when she refers to a wet signature, but I could send her some more records on the account. It's not a problem.
Jennifer, I want a trial date from you. I'm going to permit discovery for 60 days. Let's see. Discovery is permitted until July the 20. Witness list due June the 20. I'm going to make it July 15, July 15, discovery permitted until then, June 15. Witness list due, you don't have to file a trial brief at the time of trial. If you choose to file one, you have to file and exchange it not later than 7 days before the trial. I'm going to give you a date. All motions for summary have to be filed and heard now, not later than 20 days before the trial date. We're going to give you a trial date in August.
August 12th, Your Honor, at 10:30.
So I'm not going to adjourn this. Does anybody have any issues with vacations or anything at that time? August 12th at 10:30.
No, Judge.
Ms. Ginn, do you?
I'm sorry, what was the date?
August 12th at 10:30.
No.
Okay, so I'm going to put August 12th at 10:30 as the trial date. Discovery permitted until July 15. Witness lists are due June the 15th. Take a good look at this, if you would, please. And we're going to have this discovery order, this pretrial order out to you guys probably I'm sure by the end of the week, okay?
Okay, Judge.
Good luck. We'll see everybody here. Thank you very much.
Thank you.
Thank you.
America versus Christy Horner, 2500383. All right, Mr. Kirschneider, good morning again. Your name?
Michael Kirschneider for the plaintiff.
Is Christy Horner here? Yes.
She is, Your Honor. And
Yeah.
Your Honor, just so you know, the parties have not spoke. I tried sending her to a breakout room, but she wouldn't accept, and now she's disappeared. Oh, she went to the breakout room now. Let me get her back. She's back, Your Honor, and unmuted.
All right, Ms. Horner, good morning.
Sorry about that. Good morning.
Your name, please?
Christy Horner.
You didn't want to talk to Mr. Kirschneider?
Oh, yes, I did. I would like to, yes.
Okay, well, why don't we put you guys in a breakout room and I'll pass the case.
Thank
Mr.
you.
Kirschneider, you can let me know when you're ready, okay? Thanks. LVNV versus Philip Pettigrew, 2500711. Good morning, Mr. Begg. Your appearance?
Good morning, Your Honor. Jay Begg, P36820, on behalf of LVNV Funding.
Good morning. Let's see. Mr. Pettigrew, good morning.
Good
Your
morning.
appearance?
Good morning, Judge. How you doing?
Good. How are you?
Good, good.
Your name?
Philip Pettigrew.
All right. What's this one about, Mr. Begg?
It's credit card debt. The original creditor is Credit One Bank. The suit amount is $851.87. I think settlement is likely, but Mr. Pettigrew is unable to settle it today. So why don't we just do a scheduling order, maybe something similar to what you just did with Mr. Perry.
Sure. What do you mean you're not in a position to do it today, Mr. Pettigrew?
Yeah, so I got in a T-bone accident with one of my vehicles, and that was one of my vehicles that I actually was working in. Because of that, the gap insurance is not going to pay the remainder because I didn't have the car long enough. So I have to finish that up first before I can start getting this situation rectified.
I'm setting this same scheduling order, Jennifer. You're going to give me the same trial date. Nobody demanded a jury. I'm putting down 1/2 hour for trial. Witness lists are due June 15th. Discovery cutoff. If you want something from him, Mr. Pettigrew, that's the exchange of information. You can make a written request and he has to provide it. And then I'm going to set the trial date on August the 12th, was it, at 10:30,
Yes.
Jen?
That's correct, Your Honor.
August the 12th at 10:30 a.m. Okay, so we'll send out this scheduling order. I'd encourage you two to talk and see if you can resolve it. Anything else, Mr. Begg?
No, Your Honor. Thank you.
Thank you, and good luck to you, Mr. Pettigrew. You have any questions, Mr. Pettigrew?
Yeah, hopefully we can just get it rectified before that date, and hopefully everybody can be happy and satisfied with the outcome. Thank you, sir. I appreciate it.
All right, best of luck. Thank you.
Thank you, sir.
Thank you.
What else do I have here?
Next set is at 9:30, Your Honor.
All right. We haven't heard, Jen.
No, Your Honor, I'm not.
All right, what have I got? Patrick. Do you have anything else down there?
I don't have anything until 9:30.
That's all right, send them on. They're here, I can call them.
I don't have, no, Judge, I don't have any parties here yet. I'm not, Mr. Perry, do you have another case with us this morning?
Yes, I do. It's Midland versus Bovair. B like boy, Ovair. It's set for a motion to set aside default judgment at 9:30.
Most.
Judge, I will on that case mention, we did get the defendant's mail returned for some reason, so I'm not sure if she received notice. I did make a note of that to bring up, so I don't know. She has not checked in as of yet, so.
You sent it to this address on Brunswick and we didn't receive, and we got it back?
We got it back, but if you look at her actual motion, it looks like she may have changed her address, so I'm not sure.
These are the 9:30s, Judge.
But it did come back just the other day as undeliverable. But it wasn't in enough time to contact plaintiff's counsel.
We got one on Holly Lane. And we've got another on Brunswick. Where did you send it?
It looks like it may have been sent to Brunswick.
Well, it looks like when she filled the motion out in March, she was living on Brunswick, right? She wouldn't have put the, oh, wait a minute. Then she's got.
She put it up at the top, so she made it very confusing. Yeah.
Well, she's saying current address, 289 Holly Lane in Belleville. We should have sent it there. Let me do this.
Okay.
I mean, she clearly didn't get it, right? We received it back.
We received it back, but she did get, I mean, they did mail their response to the correct address, so I'm not sure. That's why I was kind of waiting to see if she appeared.
Yeah, let's give her 15 minutes. It's still scheduled for 9:30, so I'll give her 15, 20 minutes and see what happens here, if she shows up or not. Actually, I'll give her till 1:45.
It looks like Mr. Kirschenheiter is back. I'm gonna send Miss Horner a message to move back into the courtroom.
All right. All right, I'm going to recall that case, Bank of America versus Christie Horner, 2500383. Ms. Horner, your name again, ma'am?
Hi, yes, this is Christy Horner.
Good morning again, Mr. Kirschenheiter. Appearance?
Yep, Michael Kirschenheiter for the plaintiff, P75722. Judge, I'm happy to let the court know we've come to a resolution.
Okay.
Parties agreed to enter into a consent judgment for the amount of the lawsuit plus the court costs, a total judgment amount $7,690.27. Ms. Horner is going to pay $125 a month beginning in 30 days and $125 a month each month thereafter. And I could prepare that order and file it under the 7-day rule. And I did explain that to Miss Horner, but I actually wasn't, now that I'm thinking about it, I'm not sure if the court will just get signed.
Let's do this. When's the first payment due?
30 days, Judge. So there's 31 days, so 6/19.
Okay. Ma'am, do you agree to this consent judgment? That is an amount of 7,690.22, you said, counsel?
27, Judge.
27 in favor of the plaintiff and against you to begin with. Do you understand that?
Yes, sir.
And according to the terms of what he just enunciated, you're going to pay $125 per month beginning on today's the 20th, so we're going to make it June the 19th, and the 19th of every month thereafter until paid in full. Is that correct? Do you agree to that?
Yes, Your Honor.
And does he have your permission to sign your name to a proposed consent judgment that will be submitted to me, covering those terms in that proposed consent judgment?
Yes, he does.
Okay, so you can go ahead and do that, Mr. Kirschenheiter, rather than submit it under the 7-day rule. 7,690.27, I believe, right?
Correct, Judge.
Yeah, sometimes I can't read my own writing, Mr. Kirschenheiter. Anyway, so that's what we'll do. Ma'am, I wish you well. Good luck. Make sure you make those payments. They cannot garnish wages so long as you stay up on those, okay?
Yes, thank you, sir. I appreciate it.
Best of luck to you. Thank you.
Bye-bye.
All right, good luck. Who else do I have here?
No one's checked in yet, Judge, but could you buzz me for a quick second? 217.
That's always bad news.
No, it's not.
I'm just kidding. No, I'm pretty sure. I'm pretty sure I'm not going to be here, but I will. So we'd have to make it the 8th. But I will talk to you and get you an answer the next week. Okay. Thanks. All right. Sir, what are you here on?
He's here for 9:30. I don't think they're here.
What case?
It's a small claims, Your Honor, I believe.
Okay. Do I have anything ready?
We don't have any parties checked in, but Mr. Perry.
All right. Well, I'm going to get off here and then I'll come back as soon as something is ready. Sir, you can stay seated, okay?
.269, the State of Ohio versus Samuel Greer, and 23 CR 41270, the State of Ohio versus Jalen Warren. Both the defendants are present in court with their counsel, Mr. Kilburn, Ms. Tranter, on behalf of the State of Ohio. We are here And I take it that this is your motion, Mr. Kilburn. This did not originate from probation, correct?
That is correct, Judge.
All right, we're here on Mr. Kilburn's motion to terminate supervision. Mr. Kilburn, anything else you want to add other than what's in your motion?
Judge, just, they were indicted in December of 23. They were on pretrial supervision the entire time they complied with their bond. I believe they were on, at least Mr. Greer was on EMHA for a few months. Judge complied with everything. This is the first criminal case each of them have had. Prior to this, they had no criminal history whatsoever. They have complied fully with all terms and conditions. I believe their community control officers in Kentucky are recommending early termination given their compliance, consistent negative screens, and just everything that they've have going for them. They've completed all treatment. Mr. Greer obtained his GED. Judge, we think at this time it would be appropriate as they've been on community control for over a year.
Ms. Tranter.
Your Honor, it's my understanding the victim's representative is present and wants to make a statement according to Ms. Kennard. Sorry. We good?
I'm Brianna Greer.
Okay, and what's your relationship to the defendants?
Sam Greer is my father and Jalen Warren is my stepmother.
Okay, what do you want me to know?
I wanted to know if I could read my victim impact statement that I previously didn't get to read.
Sure.
Okay, she's gonna read it for me because it's very long and I'm very nervous.
You're fine.
Yeah.
Okay. Your Honor.
But let me stop you. Why didn't you get to read your victim impact statement at sentencing?
I was receiving mental health care for the trauma I endured.
So you weren't present for that hearing?
Yes, I was in the psych ward.
Okay, go ahead.
Your Honor, when sentencing was held, I wasn't able to attend due to receiving mental health treatment to help recover from this traumatic experience. I wanted to be here to read my impact statement, and if it's okay, I ask if I can read it today. I'm in a much different place now than I was when I first wrote this, but I still would like the opportunity to read this today.
I feel repulsed because I know I've never done drugs, but I tested positive for cocaine when I was in the hospital. When I found out I tested positive, it was like everything finally made sense. When I would go to the hospital, I would do so great, but when I was home, it was like I was a different person without understanding why. But now I completely understand why. I was drugged, whether it was intentional or unintentional. I had drugs in my body that I did not take. My medical records will show that I was trying to figure out what was wrong with me. I knew something was wrong with me, and I was looking for help. Looking back on what I went through, I do believe it was intentional. I can remember always getting threatened to be sent away to boarding school or residential. They tried to, but I was always rejected. I feel like they took that and decided they were going to make something wrong with me or make me feel like there was something wrong with me. My father, or the man I considered to be my father and my stepmom, gave me drugs, whether it was intentional or unintentional, and it made me feel like I was crazy. They really made me think I was losing my mind. I hated myself because I had no idea what was wrong with me. I had a referral to get tested for schizophrenia because I had no idea what was happening to me. I'm so happy I'm out of that house and away from the drugs and the environment. Yes, I have struggled, but I've never felt the way I felt the times I tried to kill myself when I was at his house. I don't know. It's just like a lot of what I went through at that house, it was like mostly just mental abuse, but the physical abuse was the only one that was like put on the records, like what he got charged for. But the mental abuse is like so hard to forget, and it's something you like never forget. And I have PTSD because of it, and I still go through that. And so while my dad has been on probation, I've been able to like have like peaceful life and stuff like that. And before he was on probation, I was getting harassed by multiple people on the internet. TikToks were getting posted about me. I was getting called and bullied every day. I was getting texted and harassed by my sister's friends, my cousins, everybody. And I just want to continue my peace for as long as I can. So I want them to continue about going on their probation as it's sentenced. And if they do get off probation, I would love it if I could extend my protection order for, I don't know, like put a restraining order against them. Because with or without it, I want to continue having peace, and I want to extend that to me and my mother, because I do live part-time at her house. And I just don't want to have anything to do with them, and I want to live my life of peace and not get harassed 24/7 by them, and that's it.
Yeah, how old are you?
I'm 18, just turned 18.
Where are you living? Where are you living now?
I have my own apartment, but I live part-time with my mother.
Where? Just the city.
Westwood.
Kentucky?
No, Cincinnati.
West. Okay, West. Okay.
What'd you say?
Gotcha. Anything else you want me to know?
No, sir.
All right, thank you. Who is the designated victim representative? I have that down as Leah Greer.
Leah Greer. She was a minor when this was going on.
That was Leah that just spoke?
No.
Okay, yeah,
No.
yeah, I'd like to hear from Ms. Greer. Hi, what do you want me to know? What's your relationship to them?
I'm Brianna's adoptive mother. I'm her biological aunt, her paternal aunt, and I adopted her.
What's your relationship to them?
This is my ex-husband and his new wife.
Gotcha. Okay. What else do you want me to know?
Just, I'm here to support my daughter.
Anything else?
That I do agree with her that they should be given the time that they were given for probation should just be finished out, because she's done a lot of growth and a lot of healing, and she just deserves to be able to have that peace and healing time without. I know that there was a lot that wasn't documented in this case, and it was real things that she was going through. Harassment from family. For whatever reason, as soon as he got on probation, it all stopped. So it tells me he put the word out, don't do it or I'm going to get in trouble. And we'd like to continue that so that she can heal.
Thank you. Is there a protection order in place?
I think there's a no contact order as a term of probation.
But there's been no protection order. I guess, I mean, this obviously happened in Warren County at some point in time, and you might want to check with the magistrates, I mean, or across the hall. Is that something that you could help them with?
I can, except for she'd have to go to Cincinnati.
Now. Hang on. Okay, is there anything else, ma'am?
No.
Okay, thank you. Ms. Tranter, is there anything else?
Nothing further, Your Honor.
Mr. Kilburn, any response?
Judge, briefly, I just asked the court to strike statements that I've heard for the first time.
To strike the statements?
Statements regarding drugging and statements that I've heard for the very first time.
I'm not going to strike any statements made by the victim. I mean, she's entitled to say what she wants, isn't she? She had a right to say this in sentencing. I'm not going to strike any statements. I mean, your clients, again, the domestic violence aside, and whatever she was referring to, the other things that weren't charged in this, I'm still allowed to consider those things under the law. But your client's got a great deal in this case from the F2 to an F3 is it a possession? Possession case.
not
I mean,
traffic.
your client's got a great deal. I understand they're doing well, but I still have to take into consideration the well-being of the victim, so I'm going to deny the request at this time. All right, that's all.
Received deferred and then violated the terms and conditions where it amounts to a motion to revoke probation. What now is the proper sentence that she should receive as far as the probation itself? To my mind, to me logically, one would look back at the original case and assess it from the standpoint of what the facts and circumstances were at the time of sentencing. And in the event that she didn't take deferred adjudicated probation at the original sentencing, what would have been the appropriate sentence as far as punishment, as far as incarceration? Would it be the type of case that would be amenable to a 1244 A or B? Is it the type of offense that would require, in light of the restitution, if restitution wasn't an issue, how much state jail time would be appropriate? Is that the way the case should be evaluated for punishment at this point when somebody's failed on probation, or should she receive some sort of additional sanction on top of what that punishment would be because she's failed at probation? Are people punished in addition on the sentencings because they failed at probation? Does that entail an additional punishment? And I would suggest to the court that it shouldn't in her case. She hasn't received any new offenses. She's paid the restitution. So in looking back at what an appropriate sentence would be on the revocation, one should look at the case as it was, and the circumstances as it was when she received the deferred, and the court should ask itself, well, what would be the appropriate punishment if she hadn't taken deferred at that point? And I think in looking at that, the court would hopefully would agree that a 1244, I would say 1244B, where she doesn't have the felony convictions, but certainly a 1244A is appropriate. That actually convicts her of the state jail offenses, but would give her the county jail time of 180 days, 180 days state jail, or 180 days county with the state jail conviction, although I would hope that the court would consider 1244B, where she would just receive the misdemeanor convictions. That would be in line with what the facts of the case were at the time that she received the deferred. Now, obviously, she hasn't done much on probation other than pay the restitution, but should she receive some sort of additional sanction or punishment for failing at probation, separate and apart from the underlying offense? And I would argue to the court that in this circumstance that would be inappropriate, that a 1244 would be the proper way to proceed.
Mr. Coleman?
Thank you, Your Honor. I'll be brief. This is one of those rare instances where Mr. Kimler and I agree she has failed abysmally at probation. Those were his words, and I join him in that sentiment. Judge, she's only paid the restitution now that an MTRP is hanging over her head. She's essentially done nothing since she was placed on probation. She goes on to probation in June of 2024, and she's not reporting the very next month or two after that. She's done nothing in the way of satisfying the conditions of her probation. Conditions, Judge, that are not recommendations by the court or suggestions by the court. It's your order. You ordered her to do these things, and she just disregarded the court's order. Even more than that, it is a waste of time, a waste of resources that could have been devoted to another defendant or defendant's judge. And based on that, I'm asking the court to revoke the defendant's probation and sentence her to no less than 12 months in the state jail.
And I would just respond, Your Honor, briefly, would 12 months have been appropriate when she originally pled?
Well, I don't know that I agree that, and I think it's a case by case situation, but where we give someone an opportunity, where I give someone an opportunity and resources that someone else could have taken advantage of, I don't know that I agree that it should go back to what it originally was. You had an opportunity, and there should probably be punishment for what you did and possibly something for what you didn't do when you were given an opportunity to not have 2 felony convictions on your record. I can tell you now, 1244 of either type is out of the question. So here's where I am. Ms. Capel, Capel, you've stated, you've agreed that you have a substance abuse issue. They tried to get you some help through JCDI. Your option today, I'm going to give you an option. 2 things. If you want to not have a conviction on your record, a felony conviction, you want to try to be successful and do better and get the tools to do better, then I'm willing to do that. But it's not going to be getting out today. It's going to be inpatient treatment through the ISF program, which is a 90-day program. Then you get out and then you're on, go through JCDI as aftercare so that you can hopefully live the rest of your life without being here and looking at go to prison. If you don't want to do that, then I'll sentence you to somewhere in state jail prison time. But it's not going to be 1244. You're not going to get to sit in county jail and do your time for not doing anything you were supposed to while you're on probation.
Would the court be inclined to indicate what the length of state jail would be
No.
to evaluate the court?
It would be somewhere in the range of what Mr. Coleman is asking for. I don't think that is an inappropriate ask.
What do you want? You have around, she's checking her back. I think she has around 2 months right now.
The thing is, and I'm not going to try to talk you into doing something, because if you don't want to take advantage of what I'm offering you, that's fine. But here's the thing. If you want to just do your time, I get it. It's probably easier to do your time and get out. But you're going to be a convicted felon 2 times over. 2 felony convictions on your record. You're not going to be able to get certain jobs. You're not going to be able to live in certain places and apartments. You're not going to be able to vote. It's going to change your life. If you think your life is negative now because you're on probation, it becomes 10 times worse with the actual convictions. If you want to take your chance and do that, then you can. But if you get out and you continue to use, you continue to do things like steal and forge checks because you're using to try to get money to use, you're going to still be in the same place and you're going to be back in here. Then you're going to be looking at felonies that are enhanced because you already have felony convictions. So that's my spiel. I'm trying to give you an option here today that is probably not what you want in the short term, but is a whole lot better in the long term. So do you want me to hold it for a minute? Y'all can go visit?
Yes, Your Honor.
All right, go talk about it. Let me know what you want to do. Beg somebody to. Mr. Gertz on Chad Holland. I see. Got it. 24 DCCR 1616.
No, I hear you. Please, no messenger shooting today.
I don't ever blame you for advocating for your client.
Maybe I should charge some extra for the trial. Maybe that was.
Run your shop the way you want to run your shop, Mr. Gertz.
That wasn't very nice. I guess it was nice.
Good morning, sir. You're Chad Michael Holland. And Mr. Holland, in cause number 24, DCCR 1616, you're charged with the 3rd-degree felony offense of fraudulently securing documents by I'm saying the wrong, deception, but it says executed documents. Anyway. And that offense is from December 30th of 2023. Your indictment alleges that you were previously convicted of burglary of a habitation, March 15th of 2004. And after that was final, you were convicted of fraudulent use of identifying information, October 7th of 2020, and also possession of a controlled substance, a 2nd-degree felony, October 7th of 2020. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is a minimum 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here that shows that the district. What's going on over there? Everybody needs to, if y'all are going to be here, you need to sit up straight in your seats. We can get you a comfy seat up here if you want to come be closer to the action. But if you're going to be here, you don't sleep in court. That's disrespectful, okay? So sit up, get your hand off your head. Everybody sit up. Eyes open, pay attention, please. So I have a plea bargain rejection that you've signed with Mr. Gertz that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be plea into counts 1 and 2 only for a 15-year term in the institutional division of the Texas Department of Corrections. Do you understand what your possible consequences are if you go to trial and what your options are? And do you want to reject that offer and have your case set for trial? Yes, sir.
I'm sorry to interrupt you. I'd like to point out that that 15-year offer was a one-time today on the offer. I communicated that to Mr. Pierce that I would waive one of the enhancement paragraphs or a couple of the enhancement paragraphs to get us to that 15 to 99 punishment range. But,
okay.
I have every intention of proceeding on the habitual offender
sure.
if we go to trial.
And y'all talked about that. And so, Mr. Holland, I want to make sure you understand that after today, I will not accept this plea agreement. If you change your mind later and want to enter a plea of guilty, it would be to something different than this or to the indictment with the minimum 25, unless there's some new information or evidence that comes to light that either Mr. Gertz or Mr. Coleman don't know about today. Do you understand? And you want to reject that offer and go to trial. Is that correct? All right, we'll get it set on the trial docket. Mr. Gertz will begin preparation. Mr. Kimler on John Mayen, sentencing, 23 DCCR 0461. I'm sorry? Yes, hold on Mayon, please. Somebody's here. Who's coming in?
We're about to tell them we don't need them because I think we have an agreement.
Okay.
If you follow, it's the recommendation of probation.
On who, what?
Corbin Thomas.
Corbin Thomas, sentencing.
The report suggested I accept, even though we essentially got kicked out of safety. It seems kind of legit though.
Okay.
It's a MTRP for messing up safety.
And he's fine with that? Mr. Kimler?
Yes.
Well, on Thomas, y'all have an agreement?
Yes, sir.
Let's get Corwin Thomas, please, ma'am.
We could, I can just tell them that we reached an agreement. Where are they? Sandy, outside of Corpus Christi. That should be Lieutenant Perez here.
You're gonna hand him anyway?
No, I was gonna let them know. Hi, Lieutenant, can you hear me?
Can you unmute yourself, please?
We're not, it's just.
Okay, yes, I can hear you.
Hey, Lieutenant, this is Luke Nichols with the Jefferson County DA's office. We've reached an agreement, so we're not going to need your testimony this morning, but I want to thank you for making yourself available.
All right, sir, thank you.
Have a great day.
Thank you.
You too.
All right, sir, you are Corwin Thomas Jr. And Mr. Thomas, you were previously in court and entered pleas of not true to counts 1, 2, and 3 in a motion to revoke your probation. So I'm guessing we need to go back through that motion for change of pleas. Is that correct?
Yes, sir. Yes, sir.
Give me a second. Pull this up. And Mr. Thomas, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And will he waive the formal reading again of that motion?
So wait.
So now, how do y'all want me to do it? If I've already revised one? And I'm gonna do it again. Take the original and do it again, or take the revised? So make another copy of the revised. Mm-hmm. All right, so there's a motion to revoke your unadjudicated probation, and cause number 24 DCCR 0542 shows you were placed on probation for aggravated robbery July 29th of 2024, and that was a 10-year deferred probation, correct? And so it alleges that in count 1, you failed to never become intoxicated or under the influence of an intoxicating substance, and that you were on February 10th of 2025. And is that true or not true? True or not true?
True or not?
Listen to my question. True or not true? Thank you. So then count 2 alleges that you're behind in your court assessed fees. Is that true or not true?
True.
And then count 3 alleges that you did not successfully complete the SafeP program. Is that true or not true? Did you enter your pleas of true freely and voluntarily? And because those 3 counts are actually true. All right, and I've received an updated report before, if y'all both had an opportunity to review that report.
Yes, Your Honor, we have.
And it's my understanding that everyone is of the opinion that even though you didn't successfully complete SafeP, that I give you an opportunity and send you to ISF to see if you can get through that and then hopefully be successful. Is that your understanding? Is that everybody's?
Yes, Your Honor. It's based on the probation officer's recommendation and my understanding and agreement that with his age and the severe consequences facing him if he is revoked, that a chance at ISF to get on better decision-making and a chance to actually complete.
And is it cognitive or substance abuse?
The recommendation appears to be substance abuse. I don't know. Is that what you suggest?
Substance abuse and followed by JCDI?
Correct.
Okay. You know, I could send you to prison today for the rest of your life. That's how serious this is. If you don't make it through ISF and you come back here without ever getting out because you did whatever was going on in SafeP, if that all continues, there won't be another chance. And you're going to go to prison before you ever even really get out to get on probation. So I want you to take advantage of this, because I'm going to look back at this and I'm going to probably think, why did I do this? And you don't want me to think that later, because it usually ends up really bad. I want you to be successful and I want you to take advantage of all of these opportunities, but you're going to have to go in there with a different mindset. You're going to have to get past however it was, whatever you were doing out on the streets, however you were living. If you want to live a normal life, have a family, have a job, just live normally without all of this in prison, then it's time for you to come to that decision and take advantage of this. Do you understand? Okay. So I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation and order that you enter and successfully complete the substance abuse track of the ISF program, and that you will then, when you're out, do the outpatient treatment through JCDI. All that's meant to help you make better decisions, get off drugs, do the right thing. If you do that, you still don't have the felony conviction on your record. And so you'll still be able to live your life without saying I'm a convicted felon. But if you violate, like I said, you'll be right back in here. You can be convicted and you could go to prison for anywhere between 5 years and up to the rest of your life in prison. You understand? All right, take advantage of this. Good luck to you.
Thank you, Mark.
Yes, sir.
Let me chisel this from there for a moment.
Okay. Mr. LeBlanc on Preston Fontanet.
could be a future of you didn't tell me. I told you so.
Do what?
With Cora Thomas in the future, it could be a you get to tell me I told you.
I know, right? Every now and then it happens that way. Every now and then. All right, so this one, he pled to counts 1, I guess.
Paragraph 1 contains a.
Count 1 previously, so we're just gonna go through that again. All right. All right, will your client waive the formal reading of the indictment?
I'm sorry.
Will he waive the formal reading of the indictment? Mr. Fontanet, in cause number 23, DCCR 20, sorry, something just popped up.
2079.
I just had stuff start coming on my computer. 2079, the state's elected to proceed on count 1 only. It alleges you committed the 3rd-degree felony offense of unlawful possession of a firearm by a felon September 29th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. LeBlanc?
Yes.
Do you fully understand them? And do you understand if I follow this agreement that you'll be waiving or giving up any right to appeal? Also, and so the agreement is the same as before. It's a 10-year sentence in prison that would be probated. You'd be on probation for 10 years. Fine, was there a fine?
$1,000 fine.
A $1,000 fine, and you would be required to follow all of the conditions of probation. Is that your understanding? Speak up, please.
Yes. Yeah.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
We have no objections, Your Honor.
It's admitted. Is there any evidence that Mr. Fontanet is not competent?
None that I'm aware of.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. We've already gone over the pre-sentence report. Is there any reason not to go forward with sentencing?
Not in light of his renewed plea, Your Honor.
Then at this time, I'm going to find sufficient evidence to find you guilty and find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, and your probation revoked, and you would be facing that 10-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. LeBlanc. All right? Good luck to you, sir.
Thank you.
Thank you, Judge.
Thank you. Jeremiah Johnson, Mr. Parker. Oh my gosh, I'm gonna need, y'all wanna, did y'all print any of those? Jeremiah Johnson by chance? It's got 4 cases. On Johnson's cases, are we going on the indictments as they are, or are there changes? Okay, I'll get through them. Y'all don't have to print them. I'll figure it out. Yeah, I got it. I'll do it. Nope. If I don't have to change them, I can, I'll get through it.
Judge, I did not write CC on there, but they're all, the deal is to run CC.
Okay. Good morning. Are you Jeremiah Johnson? And Mr. Parker, will your client waive the formal reading of the indictment in each case? Just a second. Mr. Johnson, in cause number 25 DCCR 0330, you're charged with a first-degree felony offense of aggravated robbery from February 27th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 0331, you're also charged with a first-degree felony offense of robbery from February 27th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And again, are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In cause number 25 DCCR 0408, you're charged with the state jail felony offense of theft of a firearm from February 27th of 2025. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And then finally, in cause number 25 DCCR 0409, you're also charged with the state jail felony offense of theft of a firearm from January 30th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? In all four of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes, ma'am. Would I have to do that as a kid, sir?
Yes.
All right.
And so it looks like the agreements that you've reached with the district attorney's office in the 2 ag robbery cases is for a 10-year deferred probation with $500 fines, and then a 5-year, is it 5?
2 over 5, 2 years probation for 5 on the state jail.
And then a 2-year term in state jail prison with a conviction, but probated for 5 years on the theft of a firearm case. Is that your understanding of your agreements?
Can you repeat this one?
So on the 2 aggravated robberies, it would be 10-year deferred probations, which means no convictions on your record on those 2. But if you violate a probation, it gives me the whole range of punishment. On the 2 state jail felony offenses, it would actually be a conviction of the state jail felony with a 2-year term in state jail prison. But that is, the agreement is to probate that, and you'd be on probation for 5 years in those 2 cases. Is that your understanding?
And the case is all run CC.
Yes, ma'am.
All right. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And there is also a $500 fine in each of all 4 of the cases. Is that your understanding as well? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Johnson is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we will come back at a later date for sentencing. All right, you can go back with the bailiff. Jack Hooper, Mr. Parker. Good morning, sir. Are you Jack Hooper?
Yes, Your Honor.
And Mr. Parker, will your client waive the formal reading of the motion?
Your Honor.
Mr. Hooper, in cause number 17-27896, I have a motion to revoke your community supervision. shows that you were placed on probation June 11th of 2018 for the offense of driving while intoxicated, third or more. That was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
It's true, but I get.
Well, hold on. We're gonna get to the reasons or explanations
Okay.
later. Right now, I
Yes.
just need to, if it's true or not true, okay? Count 2 alleges that you provided a urine sample February 18th of 2020 that tested positive for tetrahydrocannabinol, and is that true or not true?
True.
Count 3 alleges that you provided a urine sample September 24th of 2020 that also tested positive for tetrahydrocannabinol, and is that true or not true?
True.
Count 4 alleges that you provided a urine sample January 26th of 2021 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
And then count 5 alleges that you failed to provide verification of attending 2 meetings per week of AANA. Is that true or not true?
That's true.
And then count 6 alleges that you're behind in your court-assessed fees as of February 4th of 2021 and the amount of $2,109. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes.
And because those are actually true.
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Not really, no, ma'am.
Okay, what do you not understand?
Well, I don't know. This first time, I've only been to St. Pete, so I've never really been in trouble. I'm kind of a country boy, and I got a lot of medical issues.
Okay, so you understand that there's a reason that there's a motion to revoke your probation,
Yes, I do.
that you violated your probation, and these documents show me that you've made an agreement with the district attorney's office. If I revoke your probation for a cap of 4 years, which means if I follow this agreement, the worst I could give you is 4 years in prison. I could give you 4 years. I can give you 3, I can give you 2, I can continue on probation. It'll all depend on the information that I get when we come back for sentencing. Do you understand that?
Yes, ma'am.
Is there anything now that you don't understand about what's going on?
No.
I've explained all the options to him thoroughly, Judge, about he could go open to the judge, he could say it's not true and have a hearing and you make your finding.
Sure.
I feel confident he understands.
Okay. So state tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hooper's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing so the probation department can do an updated report. We'll come back and have a hearing on that date. Anything that you think is important for me to know, make sure you discuss that with Mr. Parker and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff.
On Warren Mills, Judge, it's one we reset to get the offer. I was just informed yesterday about 3 o'clock to get the video. And it was just ready yesterday, and Luke brought it to me this morning, so we can have a short reset so I can show them the video.
Who, Mills?
Warren Mills.
All right, we'll reset Mills.
Thank you.
Thank you, sir. Mr. Kimler, are you ready on Christy Capel?
Yes, Your Honor.
That paperwork back, please, ma'am. All right, again, ma'am, you're Christy Capel. And Ms. Capel has motion to revoke in each of those cases that we were talking about before, gave you an opportunity to visit about what you wanted to do or what you wanted me to do, and what do you want to do? Okay, good. That makes me happy. I think that's better for you in the long run. So I'm going to find that you entered your pleas of true to counts 1 through 5 in each of your cases freely and voluntarily. find those counts true, find sufficient evidence to find you guilty and revoke your probations, but I'm not going to do that. I'm going to continue you on each of these probations in order that you enter and successfully complete the ISF substance abuse track, and that you then, when you're out, go through the JCDI program as your aftercare. And then any counseling that's necessary for whatever you're going through is going to be offered, and you need to take advantage of it. Keep these off your record, live your life again like the rest of us, and hopefully this is your opportunity to do that. You still don't have the convictions, and so if you successfully complete it, the cases will be dismissed. The other side of that, though, is if you're back in here, I will see everything that we've gone through and done. And the arguments and the offers, I'm sure Mr. Coleman will remind me of what he was suggesting, and it probably will be worse on that time. Do you understand? I'm going to hand you the trial court certification. This wasn't an agreement. If y'all will sign that real quick, I'll get it. Even though I didn't revoke, let's get a copy of that. Honestly, we don't even need that. Never mind. If I didn't revoke her, I don't need to do that. All right, so good luck to you, ma'am. Take advantage of this opportunity. And then, Mr. Kimler, are you ready on John Mayen? Bless you. John Mayen?
Oh, I'm sorry. I'm not opposed if you want to go around probation's recommendation.
Thank you. And all kinds of handing out the chances today. How are you, Mr. Hill? Good. All right, you are John Mayen? Yes. And Mr. Mayen, you were previously in court, entered pleas of true to counts 1 through 5 in a motion to revoke your unadjudicated probation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Are there any additions or corrections?
No, Your Honor. Not from the state.
How old are you now? 21. So you understand that today you could be going to prison for the rest of your life for violating this probation? Yes, ma'am. Okay. You ready to do better? Yes, ma'am. Okay. You're lucky because probation also thinks that you are ready to do better. And so they've given a recommendation that I continue on probation and give you some treatment up front, some ISF, cognitive track, and then to give you some tools to be successful. Is that what you want me to do? Yes, ma'am. Anything else, Mr. Okay, it's already done. All right, so I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation in order that as a condition of that probation, you enter and successfully complete the cognitive track of the ISF program. You will be ordered when you're completed that for some time. You'll be on the high-medium caseload risk, which just means high-risk caseload, which just means you'll be reporting a little more often. They'll have a better watch, make sure you're following through with everything you're supposed to for some amount of time. If you do all of this, get the tools that you need when you're in ISF to make better decisions, do everything you're supposed to on probation, then this is your opportunity. So this is your second chance. There won't be a third, okay? You got a great chance getting on probation in the first place for this offense. The fact that you're remaining on this probation is a big deal. And so if you come back and you haven't followed through and taken advantage of this, I can assure you things will not go this smoothly next time. Do you understand? Yes. All right.
I know he wrote extensively.
I read your letter. I mean, and that's part of why I think everybody's willing to give you an opportunity, because it sounds like at least in your mind you're ready to get things right and your priorities straight. It's just getting it from here to actually doing it, right? And so it's being around the right people or being around no people at all. Go to work, go to school, go home. You know, if you want to live your life out like a normal person and not in prison for who knows how long on a case like this, then you're going to have to make some sacrifices and do everything you're supposed to on probation and make sure that it doesn't matter what anybody else around you's doing, you're doing what's right for you. All right? All right, good luck to you, sir. I'll sign that order.
Defendant needs to sign those as well.
Oh, he does. Then he just, Mr. Kimler on Peyton Woodruff.
That's a motion to reduce.
Mr. Bond.
Essentially, you get the.
Late yesterday, but thank you.
Some of the ones, you just let it take and refile.
That's okay. I'll, is it in both cases?
It's, the 100,000 is in one case, the other bonds are small part.
I'll call it one,
Right.
but then the state filed something in both.
Gotcha. All right, are you Peyton Woodruff? And Ms. Woodruff, in cause number 25 DCCR 0426 is charged with robbery. And in cause number 24 DCCR 1710 charged with burglary of a building. Mr. Kimler has filed a motion asking that I reduce the bond in the burglary of a building case. And it looks like the state has filed.
Just filed a couple of responses, Judge. We're not necessarily opposed to a reduction in the $100,000 bond. I can see where the court would be inclined to do that, but we just made some points in our reply for the court to consider.
Let me take a look.
What happened, she was on bond for the burglary of a building and then was arrested on the robbery, alleged to have committed the robbery while on bond for the burglary of a building.
That appears to be what I'm seeing, yeah.
And that's why it was raised.
What's the bond in the robbery?
And,
It's 15.
That's right, Judge, 15,000 in the robbery.
15?
Yes, Judge.
It's a simple robbery, not a robbery. It was basically a shoplifting case.
It's the garden variety.
It's garden variety robbery. So
I'm
still, it's a second degree robbery while you're on bond for another
disparaging the severity of
felony.
or attempting to impugn the severity of But basically,
Hold.
she wants to go into rehab, if the court ready to entertain the motion. And I said as a condition of lowering the bond, that she be court ordered to attend Franklin House North as a condition of lowering the bond. Do you want to do that? Is that right, Paige?
Hold on just a second. Let me look at something else here.
And she has unindicted possession cases as well,
And I guess those are just waiting on labs.
That's my understanding, Judge.
which could be, who knows how long.
I know. Same offense date as which one, the robbery or the burglary? Or are they different offense dates? Do y'all know?
Oh, different offense dates is my understanding. I put in my reply, it looks like she picked up the POCS while she was out on bond for the robbery. Well, let me reverse that. The defendant was out on bond for the POCS when she picked up the robbery, is my understanding.
She's out on bond for the burglary.
Burglary of a building.
Burglary of a building.
She was probably let out on accusation on the,
There is an underlying substance abuse problem as the court may infer from the facts.
give me just a second. I'm reviewing, just for the record, I'm reviewing the probable cause affidavit in cause number 25 DCCR 0426. So, Mr. Coleman, you're not necessarily opposed to some type of reduction, but I think there's some very,
That's not court would be inclined to reduce that $100,000 line. I just would ask that it be sufficient in light of the circumstances, including the fact that you've got 5 pending criminal cases, 3 of which are felonies, and she picked those up, all 5 of those offenses within the span of 4 months, Judge. You know, there's an argument to be made for the protection of the safety of the community in light of her recidivism, but that's really a simple ask.
If I could briefly explain my position.
Yes, sir.
I think there's a lack of criminal history here such that I think that would the state be prepared to extend a plea offer on the indicted cases, it would probably be probation. I don't want to speak out of turn, Mr. Coleman, but certainly the cases that she has that are presently indicted should be probation cases, but probably with the condition of safety or ISF. Since the state's not prepared to make an offer at this time because of the unindicted cases, she's just sitting in jail with the $100,000 bond and is not able to try to initiate a rehabilitation program in jail. And I don't know how long she's going to be sitting in jail waiting for these new cases to be indicted. So that's.
well, we're not gonna, I don't know that we can wait on the possession cases, depending on the time frame that is going on with those issues right now is not something that I'm willing to.
I would like to move the indicted cases.
Well, let's do the, okay, all right. So in cause number 24, DCCR 1710, I'm going to grant the motion to reduce the bond in that case to $25,000. I am going to order that you enter and successfully complete the Franklin House North program. Also, that you are required to wear a drug patch. Your bondsman or Mr. Kimler can let you know where to get that on. You have to get it on if you make your bond within 24 hours. You have to wear it properly. You have to get it changed every 2 weeks. If it tests positive, that bond in each of your cases is going to go up. If it's not testable, then I'm going to assume it's positive. So whatever you have to do to make sure it stays on your arm, that it's testable every 2 weeks, you have to get that done. And then we'll reset the case for an announcement. If for some reason that bond's not made, we'll see where we are at that point.
And as I said, I think I would be prepared to plead.
But y'all talk about that. That's all right. Thank you. Mr. Lewis on Derek Ardwan, 25 DCCR 0350. Okay. Justin Thomas needs an evaluation. We're going to reset Justin Thomas. And we'll get, if you'll send something over, or we can just do our order on Justin Thomas. Good morning, Mr. Lewis.
Good morning, Jill.
Good morning, sir. Are you Derek Ardwan? And Mr. Ardwan is charged in cause number 25 DCCR 0350 with sexual assault. And what is the announcement?
Judge, I've been talking with Mr. Smith about the resolution on this matter, and I think we're close, but I think he would like to speak with the family first before, so we could just maybe 2 weeks.
Okay.
We get it resolved.
All right, Mr. Ardwan, we'll reset your case a few weeks. Make sure you talk to whoever you need to so that when you come back, we can get an announcement on what you want to do with your case. All right, you can go back with the bailiff. See, Norberto Armenta, Mr. Lewis, Ms. Molfino. Good morning, sir. You're Norberto Armenta?
Yes, ma'am.
And Mr. Armenta, in clause number 25 DCCR 0168, you're charged with driving while intoxicated, third or more. And in 25 DCCR 0169, charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, on Mr. Armenta's case, there's several pieces of mitigating evidence that I'm getting released from his property and being sent to me. I've gotten an offer from Ms. Malfino, but I've talked with her about this, about reviewing that information with me, and it could possibly change the offer so we can get it resolved.
Okay.
And Judge, he's indicted as habitual. We've made an offer considerably under that based on some mitigation
Okay.
factors, but I would just like the defendant to know I'm happy to keep that open based on everything we're going to continue to discuss. I didn't want him to think it'd go back to the original.
Okay, thank you, Ms. Malfino. So we'll just do a normal reset. That should hopefully give you time to get whatever you need from Mr. Armenta and his property, get that to Ms. Malfino. We'll see if we can get an announcement at the next court date. All right, you can go back with the bailiff. Marcus Elam, sentencing, Mr. Lewis. Good morning, ma'am. Good morning. You're Marcus Elam? And Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation, on probation for burglary of a habitation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections to the report?
No, nothing's been finished.
And it was unagreed. Mr. Lewis, you may proceed.
Judge, this is a situation where it's no doubt that Mr. Elam made several mistakes while he was on his probation, not following up on his obligations. After speaking with him, he's been in custody this length of time here. He is definitely, from what he's telling me, willing and wanting to comply with the court's orders, and feels as though he could successfully complete this probation given that opportunity. He understands that his mistakes, has definitely been costly and put him in this decision. He understands that's totally on top of him, and of course he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Yes, ma'am. I'm sorry for my actions that I did when I was on probation. And if you really, I would like to start over and get right, live with my family, go back to work, help my mother died, give her bills, and everything else, Your Honor.
Okay.
And Judge, I'm sorry. I was going to say, Judge, if I may, one of the biggest issues I explained and talked to Mr. Elam about was him not reporting like he was supposed to do over that span of time. And he expressed to me that at that time, he was dealing with the death of his grandmother, as far as I think she was a big part of his support system. He does have, I've been in contact, several members of his family have contacted me about him, so he does have a support system that's there. I think she was a big part of it. And after she passed away, I think he kind of went astray at that point, my understanding, Judge.
What is the status of the 5 new offenses that are alleged?
I believe they should all be.
What happened? So what was the deadly conduct from August of 2023? What was the outcome of the, or I guess I'm trying to figure out what happened on all of them.
My understanding, Judge, is he has cases that are pending in misdemeanor court, but nothing here, Judge, that's been accepted as any additional.
He pled true to the deadly conduct, discharging a firearm, from August 16th of 2023. Anna, can you tell?
I'm sorry, Judge, I didn't look him up after he pled true.
I know, I just want to know if I want to know that. I want to know the evading, the failure to ID from February of this year. I want to know what the status of everything is.
I know those are still pending. He hasn't gone to court on those yet, right? Next door.
Andy Cohen.
Mainly, the August 16th, 2023 offense dates are the 2 deadly conducts. I want to know what the status of those are.
Which,
And PCs, if you can find them.
what else is there?
Does the evading for March 3rd, 25, our case, but when it's on, and then there was a previous trespassing case.
There's 2 deadly conducts that should be somewhere, somebody should know something about from 2023.
There was an obstruction in 2023 that was dismissed.
Birthday gentleman.
I don't have anything on deadly conducts.
What's the offense date of that one, the 2023?
5/3/23.
Daily conducts from August of 23 were refused, Your Honor.
Do you have any, I guess if they were refused, you don't have any documentation or a PC
I
or?
might be able to see a reason, Your Honor, for the refusal. I'm pulling that up right now.
Thank you.
There's not. Just said unlikely to prove.
I mean, you pled true to it, so obviously there's that. All right, Ms. Malfino, what's the state's position?
Judge, I'm kind of torn on him. Obviously, the concern is the length of time he absconded. I mean, it wasn't just a month or two. They looked for him for almost 2 years, a year and a half at least. And in that interim time period, regardless of them having been filed or refused or whatnot by the intake division, he has pled true to at least the court standard of having committed all of those new offenses while on probation, although he has no felony convictions. It looks to me like he ordered him to ISF cognitive in 23. Mr. Lewis had made mention that he never went. I don't know if they didn't have a bed for him and eventually he timed out of that, or something happened and the new offenses came up and they wouldn't take him.
I think when he had the prior NTRP, I don't know if it was at the new case or a prior NTRP, I'm not sure, but ISF was ordered, but at some point, I guess he timed out or something because he was released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to due to pending legal issues at the time, and he was ordered to complete moral reclamation therapy in lieu of, but he never.
So it was the new offenses that were holding him up.
Correct.
It looks like there was a non-prosecution affidavit on that assault bank violence, which is why it was.
He pled true to it.
Correct.
So.
I just want to let you know that's
Yes,
why it wasn't there.
perfect, thank you. So this is this. So there was a motion to revoke back in 2023. And I'm guessing continued on probation in August or sometime, right? Or did we never do anything on that because then it was amended, first amended?
That's the one who's ordered ISF.
In March of 23, he pled true to that
March.
Assault, family violence, the deadly conduct, obviously before it was reduced, and you ordered him to ISF cognitive, plus the MRT program. And subsequently, there was another MTRP.
So you get an opportunity to be on probation for a burglary of a habitation. And I'm want to really make sure I've got this right. So you get deferred probation for burglary of a habitation, second degree felony. You get out, you commit 3 new offenses, 2 deadly conducts, discharging a firearm, and an assault family violence on that same date. Regardless of what's come of those cases, you've admitted that something happened on that day, right? So you come in front of me on a motion to revoke your probation. I say, okay, let's give you an opportunity to go to ISF. But because I guess something else must have been pending, maybe misdemeanors or something, you don't go to ISF. So you end up just getting out, getting another opportunity, and then you go and evade arrest or detention and fail to ID. We're back here again. And you want to start over and you're sorry. Think about how that sounds. And you just quit going for 2 years, a year and a half, year and 7 months. You just think you were going to get to be out and we were going to forget about you? You know, I mean, how old are you now?
23.
23. You started this when you were 19. Feel like you're not taking advantage and you're not growing up and making better decisions.
And I think Ms. Faiza tried to work with him when he would show up to work with her. So, I mean, I don't object to revocation, judges, and the opportunity that we give him.
I mean, I don't know that it makes sense for me to do anything else. And it's just so frustrating, honestly, for me, for the young people to keep coming in here with offenses that have to do with shooting. While you're on probation for a felony, you're shooting. Then you get out again and you violate again and you take off. So I can't give you a 4th shot. That you've had your shots. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You need to sign that and you'll get a copy of it. You do have some rights to appeal. You can talk to Mr. Lewis about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you. You can go back with the bailiff. Frederick Gatlin, 2 cases. Mr. Lewis. Gosh, so tough. It's not tough. It's just, Good morning, sir. Are you Frederick Gatlin? Speak up, please. And Will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Let's see. Mr. Gatlin, in cause number 25, DCCR 0405, you're charged with the second-degree felony offense of failure to comply with sex offender registration requirements from February 18th of 2025, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? Well, are you sure? What do you not understand if there's something you don't understand? Speak up, please. Okay, so I want to make sure you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal. Do you understand that? So if I follow this agreement, you can't change your mind later. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone that. You're a U.S. citizen, correct? All right. State tenders number 1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Gatlin's not competent?
No, Judge.
All right, sir. In cause number 25, DCCR 0405, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements, and sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 23, DCCR 0230,
In that case, the state would abandon, would go forward on counts or paragraphs 1 and 4 and abandon the remaining counts or paragraphs.
thank you, sir. All right, so in that case, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 3rd of 2023 for the offense of failure to comply with sex offender registration requirements. And that was a 10-year deferred probation. Is that correct? The state's elected to proceed on counts 1 and 4 in that motion. Count 1 alleges that you failed to report as directed to the probation department December 12th of 2024. And is that true or not true? And count 4 alleges that you failed to register with the sex offender tracking program as ordered. Is that true or not true? Did you enter your pleas of true to counts 1 and 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I also have here on the computer some documents in that case that have your signature on them that the state's marked as exhibit number 1. Did you also sign and go over these with Mr. Lewis? And do you understand them? And do you understand, if I follow the agreement in this case that you've made with the district attorney's office, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection, Judge.
It's admitted. All right, Mr. Gatlin, in 23 DCCR 0230, I'm going to find that you entered your pleas of true to counts 1 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. You have been handed the trial court certification in each of these cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right? Good luck to you, sir. You can go back with the bailiff. Roel Gonzalez, Mr. Lewis, Roel. Let me say his name. Oh, he's incompetent. I was gonna say we could ask him. I think it's been a lot. So we've just got him and Reed. And Joel, is he on his way?
Told you 15 minutes at 10:38.
We're getting closer, everybody. There's a lot this morning. Tommy. It's a,
No, please.
uh-huh. Critic and a comedian all at the same time.
Okay.
Good morning. Are you Roel Gonzalez? And this is cause number 25 DCCR 0226. I'm going to take judicial notice of the court's file. Mr. Gonzalez was evaluated for competency to stand trial. I have received the report from Dr. Hamza dated April 14th of 2025. The finding in that report is that Mr. Gonzalez is not competent to stand trial and that inpatient restoration would be supported. Is there any other evidence with regard to competency?
Not from the defense judge.
Not from the state judge.
All right, then at this time, based on that report, I am going to find Mr. Gonzalez not competent to stand trial. I'm going to order Mr. Gonzalez to the appropriate facility for competency restoration for a period of not to exceed 120 days from the date you get to that facility. Mr. Gonzalez, you're going to get some, go to a hospital, get some doctor's care so that you can come back and then take care of your case once you understand everything. You can go back with the bailiff. Deontay Reed, Mr. Lewis,
Yes, ma'am.
and Mr. Coleman.
Yes.
Good morning. Are you Deontay Reed?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He would be.
Mr. Reed, in cause number 24, DCCR 0838, you're charged with the state jail felony offense of theft of a firearm from January 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You'd be ordered to pay a fine of $1,000 and restitution in the amount of $1,500 and follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Reed is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That way I can get more information about you, your case, and then we'll come back later for sentencing. Mr. Coleman, what is the state's position with regard to bond reduction based on that plea agreement?
Your Honor, I would point out that the defendant does have a lack of adult criminal history. However, my records indicate he does have a aggravated robbery as a juvenile, and the firearm or firearms that were stolen in this case were never recovered as well. Would ask that you,
I think I'm going to wait. I want to wait and see I want to know what went on juvenile. So we'll just leave the bond the way it is. We'll get a pre-sentence report done. That'll give me all that information and we'll come back for sentencing. All right, you can go back with the bailiff. Thank you, Mr. Lewis. Okay. He's probably, well, I guess he's got his PSI. He's going to go over his PSI. Okay, one more. Mm-mm. I don't understand. Okay, let me visit with him right now. let's get Tony Fears, please.
Thank you for waiting on me, Your Honor.
Of course.
It's
Did I-
chatty down there in the 279.
It will help.
Because lawyers like to talk.
All right, sir, are you Tony Fears?
Yes, ma'am.
And this is cause number 24, DCCR 1028. Mr. Fears was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
Not from the state. None from the defense.
And I'm guessing even though there's significant history, Mr. Smith, based on the nature of the facts, or?
Based on the totality of the circumstances, I felt like this was appropriate. I did speak with the complaining witness. He was concerned when I spoke to him about the restitution, even though the PSI kind of says he downplays that.
Was that part of the, was there?
Restitution was paid up front already.
Oh, it was already paid?
Yes.
Okay, okay,
And I forwarded that on to the complaining witness.
okay. All right, then, Mr. Fears, at this time, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Can there, we can't do it straight. It has to be deferred because there's deadly weapon.
Deadly weapon, I'm sorry, Judge.
Yeah. So, look, I caught it as we, I should have caught that yesterday when I was reviewing it. So, which actually, in my opinion, might be okay because that gives me the full range of punishment. So what I'm going to do then, the type of probation is left up to the court anyway. But you cannot have what we call a straight probation on an aggravated case. And this is an aggravated case. And so I'm going to kind of recall what I just did. And instead of making that finding of guilt, I'm going to defer all proceedings. You're placed on probation for 10 years. So it's still the 10-year probation, but it's a deferred probation. There's a $1,000 fine, and you're required to follow all of the rules and conditions of probation. So the difference about this is if you successfully complete this probation, then at the end, the case is dismissed, and you'll never have this felony conviction. The other side of that, and really kind of the side with your criminal history that I even like better, is that if you violate any condition of probation, you can be brought back into court and you could be found guilty and you could be sentenced anywhere in the range of punishment, which means between 2 years and up to 20 years. That 10-year cap or 10-year sentence is gone. It's now an open punishment range for me if you violate. With your criminal history, that's something that should be a deterrent for you, because I'm going to look back on this if you're back in here and wonder why in the world I agreed to this in the first place, because your criminal history does not support what's going on. I trust the attorneys, they know the case, I'm going to go along with it. But if you're back in here, it's not going to look good because I'm going to see all of this and wonder what in the world. Do you understand? All right. Part of your probation, and it's part of the law anyway, is obviously because you're a convicted felon on other cases, you are not allowed to possess any firearm. I'm also going to order that you not possess any type of weapon, knife, other than a kitchen type knife. You cannot carry a knife on your person or anything like that. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will talk to you before you leave today. Good luck to you, sir. Thank you, sir. You too.
Thank you, Judge.
Thank you, Mr. Vasquez, Mr. Smith.
Thank you, Judge.
Thank you, Mr. Vasquez.
Thank you, Judge.
Thank you, Mr. Vasquez. Mr. Smith.
Part of the docket, which is a docket, is a montage of different kinds of things that we have every day to deal with. There's no response to that name being called into the hall, no response to that name called here in the courtroom. Defendant has failed to appear. A warrant shall be issued for his arrest. No bond is allowed because this is a trial docket, and he may show up and he may be confused with his attorney may have missed the advice on whether he should be here, but nonetheless, the state, are y'all ready?
We are ready, Your Honor. Yes.
What's this on behalf of the state? What's the district attorney's office recommended we try this morning? This one?
Yes, Your Honor, we are.
How long do you think this should take?
We should be finished by Friday, including punishment, if we get there.
Okay, Sam Hodges, that's you, Mr. Hodge? Mr. Dusler is your attorney, correct? Have you talked to him today? Yeah, speak out so she can hear. Okay, well,
Judge, I'm sorry. I did get a call from Mr. Dusler's office. Apparently he's on vacation this week. I didn't realize.
he's on vacation.
That's,
The man's got a trial.
I understand. Anyways, it was already on the docket.
Did you know he was going to be on vacation? Okay.
Yeah, it was already on the docket, so I
Look,
told,
Mr. Hodges,
yeah, I told the secretary just.
come on up and you're gonna need to get a resetting on this. The state, are y'all ready for trial? When we get around to it?
Oh, of course.
I want to roll it around pretty quickly. It's 900 days old. That's old for, Mr. Hodges, we're gonna move this one fast.
The case,
So we're just gonna reset it a few weeks, okay?
For your honor's education, I intend to try the robbery first.
And the second degree felony of robbery is gonna be tried first.
Thank you, Judge.
Kevin Walker, Mr. Gertz, was right here. Where do you go?
I think he went to the back good.
Yeah, that's right. So I come in, he leaves? This, my ties there. Kevin Walker, are you here? Mr. Walker? No answer. No answer in the courtroom. I asked the bailiff to call into the hall for Kevin Walker. Mr. Gertz, you and Kevin Walker are together in all kinds of weather?
I went out to get him, Judge.
Good, all right. We're still trying this thing?
I mean, I'm not ready today, but I could be if I need to be. But
Well, it's 532 days old.
I should.
Yeah.
I still would be eager to get a resolution if we could do it, so.
Well, okay. Let's try to move it if we can.
Yeah.
Oh, okay. Generally, we don't try DWIs. They get resolved generally without a trial, but sometimes we do. But you can tell which cases, done this so long, certain types of cases normally get disposed of without a trial, working out a deal. And sometimes they just can't get worked out, which is why we try cases. But yeah, DWIs we seldom try because those are resolvable generally. But nobody on the jury is going to be intoxicated, so frown on that sort of thing. So what are you going to do? Let me know.
Yeah, I'll let you know.
Okay. Zachariah Atterbury, Mr. Adams, Langston Adams. There's no answer. The attorney's not here. Zachariah Atterbury is called. No answer in the courtroom. I asked the bailiff to call into the hall for Zachariah Atterbury. Thank you. Do we have any pleas off this docket that we were around?
I've got two that I am intending on pleading, Judge.
Okay. Zachariah Atterbury, that's you?
Yes, sir.
Mr. Adams, have you talked to him?
No, sir, I have not heard from him.
You know, we're in trial. You're going to be in trial today.
Yes, sir.
That's the way you're dressed?
I might have to tuck my shirt in, yes, sir.
Yeah, it's always nice to have a tie.
Yes, sir.
You want to borrow one
I
from
don't
me?
have one. Yes, sir, it'd be nice, I'll have one.
Well, why don't you have one?
I've never had a need for one.
Ever in your life as a male?
Yes, sir.
All right. That's odd.
Yes, sir.
All right, if we need to supply one, but you know, jury's going to be, the men are always dressed up in ties, so they kind of go, why, this is important, what goes on in here. You're charged with aggravated assault with a deadly weapon. That's going to be a second-degree felony.
At the first degree, Your Honor, and we also filed a notice of enhancement on that as well.
So 15 to life?
Yes, Your Honor.
If you're found guilty, you're looking at a minimum of 15 years in prison and parole on this type of, with a deadly weapon, you can't get parole until you serve 1/2 of the sentence at least. What I'm saying is, you understand and appreciate the magnitude and the importance of your life's destiny here with this case. You need to be wearing a tie. You need to dress up like your future is at stake, because it is. All right, all I can do is give advice. I mean, but you make the last decision finally, but I'd be dressing differently. I wouldn't be looking like I'm going to a clan wig, you know, like that. You just, with your shirt out, and I mean, that's sloppy. This is important, what goes on. Well, you have to act and dress like it is. There's Mr. Adams here. Yeah, between his shirt being out, his no tie, I mean, he'll tell you that doesn't impress a jury, and they're the decider of your fate. Okay. You gotta act like this is important if you don't really believe it is, but we all know it is.
Yes, sir. I mean, I have a job and everything else.
Yeah, well, you gotta dress to the part. You just can't come in. I don't care what way.
Well, I've never
The
been.
dick for clams.
I've never been.
No, don't say that. You've got prior convictions, right? Don't say that you're foreign to this atmosphere. You've been in courts before. You know, these are felonies. They're serious. You go to prison for a long time. And I was amazed where just the lack of importance some people take to this. Well, y'all ready for trial?
Yes, Your Honor.
All right, but okay. It's going to be one of the. We're going to send it somewhere, if not here. Next is, just have a seat. Sean Broussard, Mr. Burbank. There's no answer. I asked the bailiff to call in the hall for Sean Burbank. Are you Sean Broussard?
Yes, sir.
Come on out. You too. What's? Are you kidding me? You're charged with aggravated sexual assault of a child. Is this a first degree felony stuff?
Yes, Your Honor.
You're looking at life in prison. That's the way you're dressing for court in a felony trial like that? That's the best you got? Really? Life in prison is what you're looking at, sir. Your jury's not going to be dressed like that. They're going to dress like they're kind of going to church, because this is important.
Yes, sir.
The Constitution that we're talking about. Do you not appreciate the importance of what you're charged with?
Yes, sir.
Really? I don't think so. Mr. Burbank didn't impress upon you how important it is. Look around you. Look at the people who are here. You see how they're dressed? Because this is important.
Yes, sir.
And there's a respect that's part of it that you don't seem to grasp.
I haven't talked to my lawyer since the last time.
I don't care whether you don't think life in prison has its own importance. A lawyer has to tell you life in prison is a lot.
Yes, sir.
Just have a seat. He'll be here, but these cases get moved quickly too. They're by law. they get moved to the top. Lawrence Caleb. Lawrence Caleb, that's you, Mr. Caleb?
Yes. Yeah.
Yes, Your Honor, that's the dismissals on that.
That's gonna be dismissed?
Yeah.
All right. That's gonna be dismissed. Yeah.
Pretty good.
Next time, if it's gonna be a trial, wear a tie, you know, you can't, not a t-shirt. I mean, that's nice. It's got some nice Americana to it, but everybody's wearing a tie.
You're not coming back, so don't worry about it. You're good.
All right, but you're not gonna be a trial. This is gonna be dismissed.
Dismissed, yes.
Give me that. When you get that to me, I'll dismiss it. Herbert Keys the third.
Judge, I've submitted a dismissal on that. That should be on your tab.
All right, where's Herbert?
Outside.
Herbert Keys. Herbert Keys outside, please. Thanks, Dennis. Gracia Cano. Mr. Gilthar? Where's he? Oh, that's her? That's a Gracia. It's female. Yeah. What are you gonna do on this one?
That one, Your Honor, that's also a dismissal complainant signed.
Okay.
Prosecution.
I still awake up. Okay, Michaela Moaning. Michaela Moaning. Mr. M, is that gonna be dismissed or?
That's scheduled to be a plea, Judge.
Okay, Moaning, Michaela Moaning. Marvin Lewis is the attorney on that one. Please call into the hall for Michaela Moaning, please. Thank
So
you.
whenever he gets here, we intend to do some paperwork on the aggravated assault with deadly weapon. I will, as part of that, dismiss the deadly comment. But we affirmed an agreement quite some time ago, Judge.
You're Miss Moaning? Yes? That's yes, she's got to take everything down. Mr. Lewis is your attorney?
Yes.
Is he on his way?
I could take some.
Yeah, I don't want to text him, but I want you to. It looks like this is not going to get tried. I think we're going to be disposing of this case in a way other than a trial. That's what you understand?
Yeah.
We're just stand by. We're going to try. If you can text him and tell him we're waiting because we've got other things to do, but we need to get this one taken care of and disposed of so we can work on these other cases that are going to go to trial. Thank you, man. Marvin's a nice guy, very good lawyer, and he's just coming in from Houston. And that takes a little while sometimes. Daniel Harvey, Mr. Gertz. There he is. That's okay. That's your trial suit, huh? That's okay. Good luck. What?
Nothing. We could be ready on this, Judge, but we're actually.
Well, it's set for trial.
I understand.
So you got to be ready.
We've got,
yeah.
We feel like there's some videos that we did not get.
Who's Mr. Eckers?
There's a couple of different.
Sonny's never been.
First
time hearing about this.
I know. We just realized.
On the trial day, we're learning. He's pretty good at taking care of this.
I understand. Sonny, I
We'll
think
wait until the day.
they gave us a stack of videos, Judge, and it's a lot of videos. And we feel like it may not be all the videos, and so we need to get them.
How do you?
Because it doesn't show what some officers are saying should be on.
You don't know for sure.
We don't know, we know that it doesn't show what we anticipated would need to show. So it makes us think we don't have all of it.
That's kind of vague, but if they'll give me a list of what they are looking for, if the case is not reached this week, I will find it.
So it doesn't look like we're going to try this one right now.
Yes.
Right? Okay. But what's
we'll get with Mr. Eckert, Judge, and work that out.
Yeah.
okay? We got 30 degree felony and then a state jail felony. So
And that state jail, is there enhancement or is that part of the?
There's a second paragraph that states it's 1,000 feet of the playground.
I see. Okay. That's how it gets to a state jail.
Just a state fair.
Yeah. Yes, that is the right flavor.
Well, I saw you on the horse ride.
It was a kid walking up, just a kid.
The camel. Okay, that will be reset, but let's see where we had on that one. Okay, thank you. David Ring.
Sorry.
Mr. Ring.
We're gonna do a misdemeanor, so I'll give you, I'm not ready to
Get it done. So
refile the lesser included.
is it a lesser included?
It's a lesser included, but we're gonna do.
All right, get the papers, okay, as soon as you can. Mr. Ring. Okay, stand by, Mr. Ring. Thank you.
Yes, sir.
Corey Hillman. John.
Right.
Oh, you're ready?
Yeah. I knew, I saw.
Okay, that's in the trial. Taylor Williams.
Paper right here. I get a sign up. And also Mr. Keys is back in if you want to bring him up. He's one that can be dismissed. Keys.
No, I don't, the dismissals I'll just sign. Y'all just get them to me.
All
right. And finally, Centeria Guillory. Centeria, yes, Mr. Grove. David was just here.
Judge, you signed up, ready to go.
All right, let's get these please. Thank you. Done and move. So once again, we've got Joshua Sport 1, Kevin Walker back on yours. What are we gonna do on that again? That Trump?
I mean, for the moment it does, Judge.
All right, 2. Zachariah Arterberry at Stillmead Langston. And then Sean Broussard. And Michaela Moaning. That is Michaela Moaning going to be disposed of?
Judge. So Mr. Wilson gets her.
All right, who's in the queue ready? Yep, there's Marvin. Michaela Moaning she's here. There she is. We're going to dispose of that.
Judge,
It says a plea.
Judge, I do anticipate that being a plea.
Can you pick it up?
Yeah, let me talk to Mr. Ham.
Okay.
I'll bring it to you later.
Yeah. There's another one in here.
Got
Yes, Mr. Burbank, Sean Broussard. Where's Sean Broussard? Yeah, he's dressed ready for trial. Look at that. Yeah, that's nice. But he said he didn't know any better. Okay. All right, we'll try this case.
Here's the phone. Actually, that's okay.
Three. Okay. Then moving on to something else. That's 1, 2, and 3. It'll be 3. And since Zachariah Otterberry, when Langston gets here, we'll know he's the last one. 1 o'clock, right? Is that when?
Correct, yes, sir.
1. Okay, do we have any pleas in the queue?
And Judge, we do have some other cases set on
1.
another docket.
Yeah.
An announcement docket.
That's 9:30. Let me just
Okay.
try to get some things done.
This is gonna be the one that David has for a plea. Hillary. So as soon as he can give me the paperwork.
Okay, he didn't have the paperwork, but you got some other paperwork in it.
Dismissal judge.
I have an update on James Macon if you would like it, Your Honor.
Okay.
He says that he's at a doctor's appointment. He's running late. He told his client to be here at 1 for jury selection that he's ready.
Great. Oh, good. Sounds good. So we'll do. Thank you. Most for the kids, the students, most cases in criminal courts are disposed of without a trial, pleas, or other kinds of disposition. But the trials, 90, maybe 92%, maybe even more, are disposed of without the need of a trial. But trial dockets, we'll put several cases on the trial docket. We can only try one at a time. Trials take 3 to 4 days generally in this room. Sometimes they take months, depending upon the kind of case, but generally 3 to 4 days. And so what we're doing is we call the docket, find out what's going to get tried, put those aside. We got looks like 3 cases are going to be, or maybe 4 are going to be put on the trial docket, and we will see. We can only try one at a time. The others are going to have to be reset to a later time. But the other cases are going to be disposed of by agreed pleas. So much of the dispositions are doing plea hearings, and you'll see how those get done. But we'll pick a jury at 1 o'clock and then start the trial and this afternoon, and between the trial docket, which we do early so that we can find out ahead of time what's going to be tried and what's not. And then we've got another docket right after that one. Here's at 9:30. We've got a docket, and a docket, we call it a docket. It's just a set of hearings. And in this one at 9:30, for example, we will have some pleas of guilty, some announcements, whether they want to go to trial or needs some additional time to figure out whether they're going to go to trial or not, because sometimes it takes a while for discovery, the exchange of information from what the DA's office has to what the defense needs to tell their client and advise their client. Sometimes that takes months. And it's a potpourri of different things. We've got some hearings on competency. That's some defendants are not mentally well. And if you have a mental illness, we've got to, of a defendant, we've got to figure out whether he is competent or she is competent. That is, they're in a mental state where they can understand and appreciate the proceedings, or do they need to go to a hospital to get help mentally? And sometimes that happens. And then some people are insane who are unable to make conscious, correct decisions. And if it's a serious case, like all of these are in this court, where it's maybe a crime of violence, then they have to be segregated to make sure, put in a hospital until they're deemed safe to amble about the community, because we don't want somebody who is insane, which is a defense under law. If it's not your fault, if you didn't have a conscious decision ability to make a right from wrong decision, then they can't be ambling about hurting people and saying, well, I'm insane, so I can do whatever I want. Well, that's not safe for the community. So we've got to figure out whether they go to the hospital or whether they are being treated effectively with some medicine or other kinds of treatment from a physician so that they're safe. And so it's a potpourri of different things, and you'll see how that works. Okay, you ready?
Yes, sir.
Okay, who is this, David?
Centraria Guillory.
Centraria Guillory?
Yes, sir.
Right, we now call cause number 24 CR 1963, the state of Texas versus Centraria Guillory. That's you, ma'am? Present with Mr. Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here in this case? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment that was handed up by the grand jury, here's the indictment right here. And it, in summary, states that on or about June 26th, 2024, in Jefferson County, Texas, you committed the third-degree felony of credit or debit card abuse of an elderly person. That is, it is alleged that you misused a credit card and that the person whose credit card you used was an elderly person, 65 years of age or older, which is if you defraud an elderly person, a child, or someone who's mentally ill, somebody like a disabled person, then the law says it's more serious. So this is now a third degree felony rather than a state jail felony. Do you understand? That means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation. Fine $500. Restitution is owed in the amount of
$44.16.
Okay, when is that going to be paid back?
I can pay it today or Friday.
She has the money, she'll pay probation.
And that goes to a Desi Boykin. Who is Desi Boykin? Do you know that person? Who?
She was someone I was working for.
You were working for them.
She is a victim, Judge. She's.
I understand. I just didn't know if it was a relative or how close the person, or as opposed to a stranger. And then you're fined $500. And this deferred or unadjudicated probation can be up to 10 years in length. It's a type of probation where you are not found guilty. Deferred means any finding of guilt is postponed or deferred so long as you follow the terms and conditions of probation. If you fail, your probation can be revoked. You can then be found guilty by the court, sentenced up to 10 years in prison. Do you understand? This is different from regular probation, which was historically used, and we use that as well. And that's where you are found guilty, sentenced to prison, but your prison sentence is suspended so long as you follow the terms and conditions of probation. The difference is for deferred or unadjudicated probation, if you do well, the case gets dismissed and you're not found guilty. On regular probation, you're found guilty, and you're not unfound guilty. You're found guilty, you're convicted as a felon, but if you do well, the case is terminated early on probation, and you may not go to prison, but you're still convicted.
Yes.
So this gives you a second chance to do the right thing and not make a foolish mistake like this again. If I follow this agreement, you have no right of appeal of your case. Do you understand that?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes.
I show you what's marked as State's Exhibit 1, David. Thank you. Did you sign that document voluntarily?
Yes.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, and it's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer here. All of this is true at state, so help you God. All right, State's Exhibit 1, part of the record for all purposes. Is a pre-sentence report waived?
Yes, Your Honor.
All right, anything further to add? If not, I'm going to follow this agreement now and find, ma'am, you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to place you on deferred or unadjudicated probation, defer, postpone a finding of guilt so long as you follow all these terms and conditions of probation. What's the defendant's criminal history?
I don't believe she had any. She didn't have any criminal history.
10 years is not, do we want to do 5 years on this one?
Fine with that, Your Honor.
I think these amount of risk.
All right, you're going to be placed in deferred or unadjudicated probation for 5 years. You do well, it will be shortened to 1/3, which is 1 2/3 of a year. Some things you must do. Number one, pay that restitution immediately today. That needs to be in the form of a cashier's check or a money order, though. Bring it to the probation office. The amount of $44.16. That will be paid back, and that's how you fix things when it's money, is you pay it back. There will be terms and conditions of probation, which are normal and customary for this type of offense. One of the things you're going to have to do is complete a theft class that helps you appreciate and understand the importance of honesty and not defrauding others. And the probation officer here is going to go over all of this with you in just a moment. And again, that restitution is paid to the order of
Jesse Boykin, you're on.
Desi with a D-E-S-S-I-E Boykin. And this must be paid by the end of today as a condition of probation. Ma'am, do you understand what has happened today?
Yes.
All right, please see the probation officer. Thank you.
Thank you.
All right, I have some dismissals here, beginning with Lawrence Califf. Two cases, 24 CR 225 and 226. Those two cases are dismissed today. The request of the parties.
Back to sending back to work. I think we got it. Lacey.
Yeah,
You got it.
okay. I don't know why I was doing that. It did it on its own time.
Yeah, I've got two cases on Garcia Cano, 24 CR 743 and 744. Those shall be dismissed. Sign those today. That's right.
Raise your right hand, you swear or affirm to tell the truth, all truth, and nothing but the truth, so help you God. Pick up your right hand free. Okay, place it flat right there, don't roll it. Yep. No, I'm gonna darker than that.
Oh.
Yep. No. Place it right, do it here. Okay, let's do it one more time, let's get it. One more.
Herbert Keys, 24 CR 241.
Okay, you can see in front of you.
That shall be dismissed. We're ready.
Just need the paperwork from the prosecutor.
Done.
Herbert Keys,
Thank you.
dismissed. Caleb's. Two cases dismissed. Keys. Dismissed. All right, the defendant is.
This is Mr. Mayor.
Here. Who is he?
Ring, R-I-N-G.
David?
Yes, sir.
We now call cause number 24 CR 1115. The state of Texas versus David D. Ring. Is that you, sir?
Yes, sir.
Present with Mr. Kimler, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here?
He so weighs, Your Honor.
Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about March 6, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading or arrest or detention with a motor vehicle. Do you understand what you are charged with here?
Yes, sir.
There's an agreement that's been reached where you would be pleading guilty to a lesser included offense of evading arrest.
Correct. Judge. The state is opting to
Not 9404. I'm going to submit an affidavit of
manufactured home.
doubt. I wish you well. You can go down the hall. They'll give you a copy of the judgment. That judgment's entered by default. Thanks. Good luck.
Thank you, Your Honor.
Have a good day.
We're not picking up the.
You can go right down to the civil department. He'll bring the file down and they'll give you a copy of the judgment. Have a good day. Hey, you walked in here looking like a lawyer, and that's a good thing. Too many people come in looking like they're going to a ball game or something.
I appreciate that. Your Honor.
Have a good day.
Thank you.
All right. I don't need them out unless they're ready on that. I'm gonna call.
They are out, Judge.
All right, let me take you, Ms. Kingsley. First Choice MHLLC versus Marshall Shearer and Robert Rice, 2403493. Good morning, Ms. Kingsley.
Good morning, Your Honor. Brianna Kingsley appearing on behalf of the plaintiff.
All right, where are the other two? Rice and Shearer.
Here, he just needs to unmute and turn his video on.
Oh, there you are, Mr. Rice, bottom corner. Can you unmute and start your video, please, Mr. Rice? And then I'll need Mr. Shearer in here.
Mr. Shearer is not here.
So he's going into default.
Mm-hmm. And Mr. Bryce and I have an agreement to
Mr.
place.
Rice, you got to start your video, sir, and state your name, please. I love Zoom. I mean, I really don't mind it until I feel like, I don't know. I don't know what to say. I mean, I don't mind it, but then I get this kind of nonsense. Like, where's he at? He should, can you chat with him, Jen? Mr. Rice, I need you to, there you go. Okay. Now, that's all right. You're fine. Now unmute in the bottom left-hand corner of your screen, please. Your name. Okay, so I'm going to call the case again. It's First Choice MHLLC versus Marshall Shearer and Robert Rice, 2403493. Mr. Rice, your name.
Robert Curdington Rice, Jr.
All right, Ms. Kingsley.
Brianna Kingsley for the plaintiff. So,
And,
Your Honor.
Go ahead.
So, Your Honor, this is an action for claim and delivery for a manufactured home that is currently in default. So, Mr. Shearer no longer lives in the home and evidently lives somewhere in Maryland, unsure of his exact location. We've gone through the appropriate methods to obtain alternate service and had submitted a request for a default, and then the court had set this for hearing on entry of the judgment. So Mr. Rice and I have actually come to a resolution today, and I've spoken with my client. We're going to enter into a consent order for possession of the home. Mr. Rice, so this will enter by default as to Mr. Shearer. This will be consent as to Mr. Rice. So they can retain possession of the manufactured home so long as the past due, well, the accelerated balance of $58,422.34 is satisfied on or before May 30th of this year. If it's not paid in full by that date, then my client may submit an affidavit of noncompliance and a proposed judgment for possession. Mr. Rice and I have already gone through everything. He indicated that he was approved for a loan through Rocket Mortgage and intends to have the entire accelerated balance paid, and thereafter the loan would be satisfied.
Okay, so
I know that's a lot, Judge.
Oh, that's not 58, 422, 34.
34.
You're sure you're gonna have that, sir?
I believe so. This is what my daughter tells me. She's the one taking care of this for me.
Well, okay, so why
I was
don't
told-
you, hang
I was
on,
told that this would.
hang on. So you want to submit a consent order of dismissal that says, consent order of possession that says that he's going to pay 58, 422, 34 on or before the 30th. It's going to be a default as to sure. If he does that, then he obviously retains the property. If not, your client is going to submit an affidavit of non-compliance and take ownership. True?
Correct.
Do you understand and agree to those terms, Mr. Rice?
Yes, sir.
Well, I want to make sure you can pay it. You positive you're going to have the loan go through in the next 11 days? I mean, we have Memorial Day coming up and everything.
That's what I was trying to explain to you a moment ago. It should be done by the 27th, but it could be done by the end of the week.
All right, listen, why don't you give him another week or so, will you, please? Tell him the judge wants you to give him another week. June 10th. Can we make it June 10th?
Can I call my client? It would have to be an updated accelerated amount as of that date. So I would just have to get the new balance because as it continues, I mean, late fees are going to continue to accrue.
Why don't you wait right there, Mr. Rice? Why don't you wait right there? But if he does June 10th and he pays by May 30, you still only have to pay the 58, 422, 34. You can put that in the judgment, right?
Correct. Yeah. Let me just call my client really quick to get the
All right,
updated.
I'll go on to another case. Just stay right there, sir. I just don't want you to lose it because something weird happens. You don't get the loan out, right?
Yeah, and now I mentioned this tablet
I got it.
and me losing you.
All right, give me Cornell and Plumbing, Edwards Plumbing. Do we have that file here?
Right to the podium there.
I need the file first, so wait 1 second. Virginia Swindle versus Tracy Linville. Nobody appeared on this. This was a show cause scheduled. Nobody appeared. I'm gonna go ahead and just reschedule the show cause, Jennifer. Ms. Swindle has a hard time getting here. So let's reschedule the show cause and give her another date. Put it out about 3 weeks. Will you do that for me, please?
No problem.
All right, now. Robin Cornell versus Edwards Plumbing and Heating, Inc., 2404088.
Yeah, any part of this? Right to the podium.
Well, she doesn't need to be, just the lawyers.
Is she good, Your Honor? Sit there.
Yeah. Mr. Gutner, your appearance?
Good morning, Your Honor. Patrick Gardner, P 70106, appearing on behalf of the plaintiff, Robin Cornell.
Mr. Kavanaugh?
Good morning, Your Honor. Philip Kavanaugh appearing on behalf of defendant Edwards Plumbing, 59404.
All right.
I believe, Your Honor, that we have reached a settlement.
Okay.
Put that on the record.
Perfect. Go ahead.
Your Honor, may it please the court, and we'll have defendant's counsel prepare something in today. We've agreed to settle the matter in its entirety for the sum amount of $12,000 payable within 30 days from the defendant to the plaintiff through my office.
And a release will be executed, release of all claims by either party or just the plaintiff?
By the party.
All right, you agree to that, Mr. Kavanaugh?
We do.
Why don't you come on up here, Ms. Cornell? All right, so no question but that the defendant can pay that within 30 days?
I believe, yes, 30 days is fine.
Ms. Cornell, come on up here, tell me your name. Do you understand what your lawyer just said? You got to keep your voice up for me, okay? Your lawyer just told me that he's settling this case and you agree to settle the case for $12,000. That would be a full and final settlement of this claim. You would be releasing any and all claims arising out of this event, transaction, or occurrence for all time against Edwards Plumbing in exchange for this agreement. Do you understand that? Yes. So you understand you can't go back and sue them for any reason arising out of this claim that you have as set forth in your complaint?
Yes.
You could go to trial, you might get more, you might get less, you might get nothing. Do you understand that?
Yes.
But knowing all that, you wish to settle for this amount?
Yes.
And you're authorizing this claim on behalf of your, resolution on behalf of your client, right, Ms. Kavanaugh? All right, good enough. Submit your paperwork. Is this gonna be in the form of a, just a stip in order to dismiss, or are you guys doing it by way of a judgment?
I'd like a judgment, Your Honor.
Yeah, and so you're gonna enter into a judgment for 12,000, correct, counsel?
Yes.
All right, you guys submit that judgment, hopefully in the next couple days. And I'll sign it, we'll be done with it, okay?
I appreciate your time.
Thank you both, have a good day. And good luck, ma'am.
Judge, I don't know if this matters, but she just showed up.
Oh, jeez. Where is she?
She's right here.
Why are you showing up late?
I couldn't get out of work, Your Honor.
You can't do this.
It's happened so many times.
You can't do that. All right, I got it. Just wait 1 second. All right, Ms. Kingsley, did you get a chance to talk to your client yet?
Hey, Judge, they're fine with the June 10th date.
Let me call the case. First
I just
choice,
have to add
MHL. First
the
choice.
numbers really
Wait.
quick.
First choice, MHLLC versus Marshall Scherer and Robert Rice, 2403493. Mr. Rice, your name again?
Robert Crittington Rice Jr.
All right, Ms. Kingsley?
Brianna Kingsley for the plaintiff.
All right, so did you get an extension for Mr. Rice here?
Yes, I did, Judge. I'm just adding up the final numbers with the legal fees and late fees. So the accelerated balance alone on the loan is $58,422.34. And then there's legal fees of $2,330.30 so far. And then I'm just waiting on one more invoice for an additional legal fee that I need to add in.
So the agreement between the plaintiff and the defendant calls for attorney fees, does it?
Yes, these are attorney's fees that have accrued during the pendency of this case that my client is entitled to reimbursement for.
Yes, per the agreement that was reached. Let me just double check. Not that I would ever think that you would ever ask me for something that you're not entitled to, but I do want to check on attorney fees here. What page of the agreement is it on? Can you tell me?
Yeah, let me look at the purchase agreement really quick. Let me pull it up. Here it is. Okay, it is of charges.
Well, I'm just paging through it. I don't see anything that's entitled attorney fees.
Just give me 1 second, Judge. I'm going through the purchase agreement. It's always on the-
I hope you're not gonna. If lender elects to accelerate this note, lender may require borrower to pay all costs and expenses during the enforcement of this note and those incurred during the recovery, restoration, liquidation of any collateral specified in this or any attendant collateral attachment agreement to the extent not prohibited. That doesn't specify strong enough for me that they're required to pay attorney fees. I don't see anything. I'll tell you what, I'm gonna go on to another case here, okay?
Yeah, can we just pass this matter for just one moment?
Stay right with us, Mr. Rice, okay?
Okay. Yes, sir.
Virginia Ann Swindle versus Tracy Lynn Linville. 2402676. Your name?
Tracy Linville?
Boy, between you two, I feel like this case has been going on since I was a kid.
I know, right?
And that's not true, but I mean, it's been going on for a small claims case.
Yes.
So you didn't appear for creditor's exam on April 21. You can't miss these. That's a subpoena. That's an order of the court, ma'am.
I'm sorry. I missed so many
I
days
want you
from
to,
work.
I know,
just started.
well, I get it, but you cannot miss court. I mean, I could hold you, listen to me, listen. When'd you get the job?
Just before court started, when did we start coming?
I know, but you can't ignore a subpoena. Are you kidding?
I didn't even know it was a subpoena, I'm sorry. It was just a court date.
And now she's not here.
She's never here.
Well, no, she's been here a lot more than you have lately. Where do you work at and what days?
I work at Novellis Lab.
What days?
I work midnights, weekdays, 5 days a week.
Well, tell me what you work, what hours?
I work midnights.
I know, but what hours? 11 to 7?
No, 11 or 12 to 8.
Okay, so why can't you get here? You're making it sound,
Well,
oh, wait a minute.
Sorry.
You're making it sound like you can't get here because you can't take off of work. Wait a minute. We don't conduct court at 1 o'clock in the morning or 3 o'clock in the morning. I just don't want to hear that.
I understand.
You cannot ignore subpoenas. I don't get this society of ours. We don't think court orders mean anything anymore. I'm rescheduling the show cause. I'll set it for later in the morning for you. Don't miss.
I appreciate that.
What time were you supposed to be here this morning?
I couldn't find my paperwork.
8:30. If you walk in at 10:10.
I'm sorry.
I just want to know what everybody would think of me if I scheduled cases at 8:30 and showed up at 10:10. You know what they would think? I wouldn't blame them. I'm going to reschedule this show cause. I'm going to set it later in the morning. I expect you to be here. You better bring all your papers for the credit that you were supposed to bring for the creditor's exam. Do you understand? Jennifer, I want you to give her the subpoena, a copy of the subpoena.
Okay.
And you're gonna bring all those papers to the show cause with you, okay? We're gonna give you a date right now, so it doesn't get lost in the mail or the dog eat it or anything else, all right?
Sure. I never got those full paper.
Jennifer, give me the date, please.
June 17th at 10 a.m.
June 17th at 10 a.m. I don't believe my packet has the subpoena. I trust you do.
Yes, I do, Your Honor. I'm
But she's
printing it
gonna
right
give
now.
to you. And you have to bring tax returns. It's gonna spell it out. I expect you to bring everything, so you better get started on that, okay? June 17th. You got it?
Yes, thank you.
You're gonna go down the hall and get your date. Send it out to Ms. Swindle again. June 17th at 10 a.m. Good luck. John and Aaron Purcell, is anybody here on that? Versus Gok and Sons Towing, 2404841.
Good morning, Your Honor.
Your name?
Michael Scott.
Where's the plaintiffs, Lisa? Are they here?
Judge, I've not heard anything from them. Let me see if we can reach out to them really quick, only because there was, this was given to Dino, and I just want to make sure they got the correct date.
Yeah, they're supposed to be here at 9:45. It's 10:17 or thereabouts.
Am I allowed to move for a dismissal?
I'm gonna dismiss it if I don't get a real good explanation. They're probably gonna file a motion to set aside the dismissal. Welcome to my world.
Yeah.
Court dates now, they're not about as important as whether or not somebody cuts their lawn. I mean, I don't get it. They sue you and then they don't show up.
Yeah, in my business, I see it all the time.
Well, it's ridiculous. I don't know that we need to send him this is the plaintiffs.
Right. On the defense.
Jen,
Yes, Your Honor. I know there was some confusion because we sent certifieds that were unclaimed to Gotch and Sons. So then the personal service went out and I just want to make sure that he had the correct date. With changing of the dates. This is not the initial date that was ever set on this.
so
We
you
started
call-
trying to serve, yeah, we're reaching out to him right now. We started trying to serve this for a court date in February.
Sir, why don't you have a seat? I'll be with you in a second, okay?
Yes, sir.
Judge, can I just have one more minute?
Yeah, take your time. I'm waiting. I'm calling another case. I've got another case going. Take your time.
Okay, thank you, Judge.
No problem. Where is, doesn't require an act. Hi. Okay, thanks. Okay, thanks.
Judge?
Yes.
Okay, my client's gonna agree to do the consent for the 58,422.34.
Wait a second. Wait, I gotta go back and call it. Is that what you want?
Yes, please, I'm ready.
First Choice MHLLC versus Marshall Shearer and Robert Rice, 2403493. Everybody's name?
Brianna Kingsley for the plaintiff.
Sir, your name? Mr. Rice, I need your name, sir.
Robert Crittenden Rice Jr.
All right.
All right,
So-
Judge. So we've agreed to enter into a consent order for possession of the manufactured home. The final accelerated balance due on the loan is 58,422.34. And my client has agreed to give Mr. Rice until June 10th, 2025 to have that paid.
Okay, now this does not include attorney fees because I was right?
This include, well,
John, you have to take off your hat.
Oh, I'm sorry. Good morning. I just making sure, just getting logged in here.
hold on one second. I grabbed the wrong
You just muted again.
I grabbed the wrong document. I'll be right back.
Okay.
Sorry, Judge.
We're so nice, this would be disturbing, but go ahead. Go ahead, take your time. Jeez. All right. Let's do this. John and Aaron Purcell versus Gawk and Sons Towing, 2404841. Sir, your name?
My name is John Purcell.
Where's Aaron? Is she with you?
No, she is at work. As I was explaining to your secretary, Your Honor, is that I didn't get the second notice of the rescheduling for today, May the 20th. I did get a notice and a telephone call in regards to having to reschedule the last time, as well as Gotch's and Sons and was not picking up their mail, so I had to hire a
All right,
private.
but I don't need to hear a big, long explanation. I just wanted to know if she was here. Why did you list her? Who owns the vehicle?
Who owns the vehicle? It is it's my wife and my father-in-law that's on the title.
She should be here. Jeez. You can't get a hold of her?
No, she is a branch manager of a bank. So usually throughout the day, I don't speak with her until about 1 p.m.
Well, I'm gonna need to reschedule then. You can't really stand in here. You don't own the vehicle. Right?
Okay.
This was her vehicle that she owns and your father-in-law owns that was towed, right?
That's correct. And it's the bill is in her name, it says on here.
Yeah, so if it's her name, she's gonna have to be the one. Did you tow the vehicle? Your name?
My name is Michael Gotch.
I just want to try and see if I can help people resolve this or understand it.
Here's where I have a question and concern. We're in small claims and this car was removed because it was abandoned on private property and it was requested to be removed by the property owner. So MCL 257.252A allows for that to happen. And the only and sole remedy in a case about an abandoned vehicle is to have a hearing that needs to be within 20 days of the incident. This is far exceeded 20 days. And therefore,
It was back in December of 24, right?
right. And it clearly states in the statute that that is the sole remedy for an abandoned car case. So even if they're not.
I'm very uncomfortable taking care of this now with the proper plaintiff not being here, since the proper plaintiff didn't receive notice. So here's what I'm gonna do. Sir, I want you to write that statute down. Maybe you can talk to a lawyer, Mr. Purcell.
Okay, Your Honor, I just want to say something though.
Hang on, no, please,
Okay.
just write the statute down. MCL 257.252A.
I got MCL 250.72.
Oh, no. MCL 257.252A. MCL 257.252A. You might want to have your wife talk to a lawyer.
We did, Your Honor.
Hang on a second. I cannot go on this without your wife being here. We didn't give her proper notice. I'm going to adjourn the case out. Sir, you can appear by Zoom. I know. I'd rather that everybody appear in person, but you came here. It's not your fault. Do you have a lot of documents for me to look at or anything? You got a big notebook there.
Well, because.
I just want to know if you have a lot of documents. I might tell you have to come if you're going to bring in, if you're going to scan 87 documents and they have to bring them to me.
Yeah, I'll come in person.
All right, let's adjourn this, Jen. Give me a date about 3 weeks out.
June 3rd,
What time?
9:30.
So I'll just say plaintiff did not have notice. Real party in interest is the wife. Real party in interest is the wife. So you're not going to be able to talk about this, sir, is Aaron Purcell, okay? I don't know anything about it. I'd like to, that's it. Okay? I'm
right,
sorry,
thanks.
everybody. And again, if you don't have a ton of documents you have to have scanned, I mean, I can't imagine what you got in that
I
notebook.
have a lot of photos and there's a lot to this abandoned car removal. I could go on and on. The wrong parties being served, there's a whole laundry list of things here. That's not proper and going on with abandoned car removal. It shouldn't be in small claims.
Right. You better, why don't you talk to a lawyer, Mr. Purcell, please?
We already have, Your Honor.
Okay, good enough. I'll see you guys.
That's why we're coming here.
Thank you very much. Thanks.
Thanks.
First Choice versus Marshall Scheer and Robert Rice, 2403493. Ms. Kingsley, your name.
Brianna Kingsley for the plaintiff again.
All right. Mr. Rice,
Yes, sir.
your name.
Robert Crittenden Rice Jr.
Now you can go ahead and tell me what the deal is.
Thank you, Judge. Okay. After I removed all of the legal fees, the total payoff amount that is due by June 10th, 2025 is $56,092.04. While I do understand the court's position that paragraph 9F of the purchase agreement is not sufficient, we do disagree with that, and I would just like to note that for the record.
Yeah, I get it, but you know, to me, if you're gonna start collecting attorney fees, it better be abundantly clear, and it doesn't say it doesn't even mention the word attorney fees. It does say costs. Let me just double check.
Yes, it does reference costs. I believe it says costs and,
Expenses.
yeah.
And
costs
that
and
isn't
expenses.
good enough for me to have me give you attorney fees. They have to be specifically spelled out as far as I'm concerned. So, sir, you saved a couple of $1,000 and you're gonna get till June 10th, but don't play with this. If you get the money today, pay it tomorrow. You with me?
Yes, sir.
All right, so that'll be a default versus sure by consent. You understand everything and agree to everything here, Mr. Rice?
I sure hope so.
Well, you have to pay 5609204 by June the 10th. If you don't, they're going to submit an affidavit of non-compliance and they're going to get the home. Do you understand that?
Yes, sir.
And you're sure you're going to be able to pay this, right?
According to my daughter, she's helping with this situation through Rocket Mortgage. See, Your Honor, I come into this with an 815 credit score before I signed for this loan, and I'm down to 635.
What happened?
I signed for this loan and they're not paying it. My daughter can't because Marshall left. Marshall Shearer left.
I see. You co-signed.
Yes, sir. That was a big mistake. I'm trying to help people and this is what I get.
I know. I get it. Yeah, it's not a good idea to co-sign. I know we want to help our family, but sometimes some people tend to get with the wrong people in relationships. They're not very, let's call them responsible.
This is her stepfather, Marshall Shearer.
Okay, well, I don't
Of
know.
all things, you know,
Anyway,
here
that's up.
I'm signing for a loan for my ex-wife's husband because he died.
Well, you're a good man. You're going to be taken to the right, you're going to go to the right place, sir. I don't know what to tell you. And I
Thank you,
mean
sir.
that. I mean that.
Thank you. That means a lot.
What's that?
Thank you. That means a lot.
I really wish you well, sir. Good luck. Just make sure you pay that and then you got the home. Good luck.
Thank you.
One
Have
final-
a great day.
You
One
too.
final
Thanks.
question,
Sure.
Mr. Wright. Do I have
Yes.
permission to sign your name to the proposed agreement and e-file it with the court?
Yes.
Okay, all right. I will get that drafted and filed with the court.
Thank you very
Okay.
much, Ms. Kingsley. Always a pleasure. Have a
Thank
good-
you, Judge.
Good luck. Thank you.
Thank you for your patience this morning, Judge. I appreciate it.
No problem.
It's an 11 o'clock.
Do I have everything done until 11 now?
Everything's done till 11.
What's this, the set aside of the conviction?
Yes.
Where's that at?
Do you want it?
Yeah.
brought this all about. I haven't had a drink and the number was quite high.
When is your,
Did it get through to me since this incident?
did you have the 94 conviction set aside?
I'm trying. I'm in the process of doing both. The reason for all this is I had a Nexus card twice, to be able to go to Canada for global entry. And this third.
Where's your first one apply? Where was your first one?
In Monroe County.
Well, you can't have both, it looks like to me. You can't have both set aside. Did you receive the prosecutor's response?
And it also says in the part with, we took it as up to the judges because with, number of felonies or number of other misdemeanors, the number was quite high.
When is your date scheduled for the hearing in Monroe?
We don't have it yet. They're waiting on something. They were ahead of this court, and now for some reason, they're behind us on this date. We're not exactly sure when that's gonna be. Really, this all come about trying to get a Nexus card through Canada. That's why I'm trying to do this, so I get global entry for traveling. I've had 2 Nexus cards that didn't bother me before, but with, I guess, the world politics that's going on right now, they decided not to renew it this time. So that's what brought this all about. I haven't had a drink since this incident. We're going on 29 years.
Good for you.
And like I say, the only reason I'm here to even worry about this, I'm not applying for jobs anymore or any of that stuff. It's simply to try to get the Nexus card so I can get global entry. Canada denied
You
me.
can only have one set aside as I'm seeing this. And you've got
is
Stephen Fowler. This is 96 CD08 028 Your name?
John Stephen Fowler.
Were you in front of me on this case?
No, I was in front of Judge Schwank.
Wow.
Did it get through to me since this incident?
Did you have the 94 conviction set aside?
I'm trying. I'm in the process of doing both. The reason for all this is I had a Nexus card twice, to be able to go to Canada for global entry. And this third.
Where's your first one apply? Where was your first one?
In Monroe County.
Well, you can't have both, it looks like to me. You can't have both set aside. Did you receive the prosecutor's response?
And it also says in the part with, we took it as up to the judges because with, number of felonies or number of other misdemeanors, the number was quite high.
When is your date scheduled for the hearing in Monroe?
We don't have it yet. They're waiting on something. They were ahead of this court. Now, for some reason, they're behind us on this date. We're not exactly sure when that's gonna be. Really, this all come about trying to get a Nexus card through Canada. That's why I'm trying to do this, so I get global entry for traveling. I've had 2 Nexus cards that didn't bother me before, but with, I guess, the world politics that's going on right now, they decided not to renew it this time. So that's what brought this all about. I haven't had a drink since this incident. We're going on 29 years.
Good for you.
And like I say, the only reason I'm here to even worry about this, I'm not applying for jobs anymore or any of that stuff. It's simply to try to get the Nexus card so I can get global entry. Canada denied.
You can only have one set aside as I'm seeing this. And you've got 2. Look, I need to look at this a little bit better. You don't have a date at all in Monroe?
No, we don't, no. We had a date and then they didn't get paperwork back from the state, from the Attorney General. So they've canceled that date and now we can go by there on the way home and see what's going on. I don't know what the holdup is. If you guys have seen everything, they should have.
Ma'am.
Oh.
I can't let you talk.
25th of June, I guess we have it scheduled, correct.
I'm going to go back and look at this. Lisa, I want to adjourn this, okay? I'm sorry. I want to go back and check a couple things. The way I read this, you can't have the second set aside. So whether it's this one or the other one is not, I don't believe you can get them both set aside. But I want to go back and double check. Jennifer, let's adjourn this over a couple weeks, and I will make sure I do my due diligence to find out here, okay? I promise you. If you want to appear by, where do you live at? What city?
Monroe.
I mean, do you know how to operate Zoom?
Yes, I do.
If you want to do this by Zoom, I don't have a problem.
That would be great.
Okay, where is the file? Is this it? So Jennifer or Lisa, just, I don't know what day we're going to adjourn it to. Do you want to just give them the date down there?
June 10th at 11.
All right, so we'll do June 10th at 11, okay? And I just don't really have a register to write on here. So can you put that on there somewhere?
Yep.
June 10th at 11, and then I want to see this file like a couple business days before that, okay? Thank you. I'm sorry. I'll see you June 10th at 11.
I guess this way you read the other part, we wouldn't have wasted your time. I'm hoping that.
Well, I don't think you can get both, is the problem. I don't believe you can get both, and I know what you're talking about, gaining entry to Canada with this single drunk driving is not good, right? I mean.
The funny part is they already, I had 2 Nexus cards already, they okayed it twice. But due to the climate, I'm assuming, of the political forum, they've tightened up or I don't know what happened, but I've had Nexus card twice because I had all this stuff. Didn't realize that I didn't have it until we went to renew and, so here I am.
Good luck. We'll see you in a couple of weeks or 3 weeks, I guess, 2-3 weeks. Thank you.
June 10th at 11 o'clock on Zoom.
Correct. And she'll give you that information. Go down to my judicial clerk down the end of the hall, okay?
All right, very good.
Have a good day.
Thank you, Judge.
So I want that stuff given to me, so you can, actually, you can just copy that now for me. Did I call these LVNV versus Latif and Velocity versus Stewart? I don't remember calling Velocity versus Stewart.
That's not none of that.
You took my.
Yeah, try to. There.
It's not even on.
Taking off the doctor.
Yeah, that's what I'd like you to check out. Tabitha, have you had a chance to do those retractions?
No.
I'm gonna give you some more.
Okay.
All right. Thanks.
You got it, are you taking care of
So
that?
you got nothing? Yeah, I'd like to see that.
11:15.
that way because she had things to do. Ms. Brinson? Really? So she was so impatient waiting for me, and I can't get her on the camera. Thank
Judge,
you.
I'm right here.
State your name.
Alicia Stevens. How you doing today?
I'm okay. Counsel,
That's
go
good.
ahead with your petition.
It's going fine. I'm just trying to get this little last thing off of my record so that I can carry on with my life.
Okay, so maybe you didn't hear me. I said, counsel, go ahead with your petition. That'd be
Oh,
your
I'm sorry.
attorney.
Thank you,
Go
Judge.
ahead.
Thank you. This is my client, Ms. Brinson's application for an expungement for a 2009 conviction for operating while intoxicated. My client is now 42. She is self-employed. She works primarily in the cleaning business, and she also has her own food truck. She volunteers very consistently in the community in the city of Detroit. She participates weekly in making sure that the homeless in her community are fed. She does have one minor child who's 10 years of age. The reason that she's asking that this court grant her application for an expungement is so that she can explore other employment opportunities. This conviction has impacted her ability to obtain employment. There is a letter from the Attorney General's office wherein no objections were stated, and we respectfully request that the court grant her application.
Any response from the people?
Your Honor, I wanted to be clear if the application is to the OWI account only or all three accounts.
The petition here I have is only to the OWI.
Then I have no opposition.
Brenton, is there anything you want to say?
I just want to say that over time, of course, like I said, this was a situation where hello, can you see me? Okay. This was a situation where I was trying to do the right thing by parking and, realizing we all went out that night. My friend who was supposed to be the designated driver left with her boyfriend, so I had to drive. I realized I was too drunk to drive. I pulled over at Tim Hortons to go to sleep. And that is why I got the DUI when the police came up to my car. So I tried to do the right thing. That I was young-minded. A lot has changed since then. I'm now a home health care worker for the state of Michigan. I have a client that I have to be to at 2:30. So that's what I was. So I wasn't rushing you, but a lot of things have changed since then, Judge Simpson. I was before you before, and I was telling you that a lot of things have changed. It has gotten better. I do have my food truck in the driveway now. So things are good. Things are different. I've grown into my adult phase, and I just want to say respectfully that I apologize to the community for, the things that I was accused of doing.
Thank you.
No problem.
The court, having heard the allocution of defendant, an opportunity having been given to the Attorney General and prosecuting official to contest this application. Court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the conviction and is consistent with justice and the public welfare. The petition is hereby granted.
Thank you, Your Honor.
I've signed that. Thank you.
Thank you. Have a great day, Judge Simpson. Take care.
You do. You too.
I don't know. Weeds. All right. Make sure your phone's off, right?
Stay seated.
Court is back in session.
Is that what you hear?
Is that what you need? She's out.
People against Lance Alexander McCandless,
Right to the podium here.
23T640185. All right, your name? So on May 15th, you pled guilty, right, to appear to provide proof of attending AA twice a week, from March 25th to the current, and then appear to attend the ARM program on May 3rd and 4th. I set a sentence date here. Before we go on, I want to remind you of the right to a lawyer. Be happy to appoint you one at public expense if you would like one. Would you like a lawyer?
No.
Okay, did you bring proof?
Yes.
Have you shown that to Ms. Tessino yet?
I ran into her, I told her I had, she asked me if I had it, yes. I see her right after.
All right, well, Ms. Tessino, your name?
Emily Casino?
Let's see what you have.
Yeah, this is March 30th through current. So what I'm missing.
Okay, what do you think we should do here?
So I did hear from his therapist, she can confirm that he went to the appointment last week and just that they made some medication changes. But she hadn't spoke to the psychiatrist directly yet, but I hope that's a step in the right direction. I mean, my suggestion was just gonna be maybe some community service. Lance and I talked about how he maybe wants to get back to the gym, and if he goes to Victory Gym for his community service, maybe that will push him to do so.
All right, anything else?
No, Your Honor, I'm working on my faults, so that's all I can say really.
All right. Keep you on probation. Additional cost of $75. Serve 4 hours of community service by June the 7th, okay? 4 hours by June the 7th, pay cost of $75.
And then are you okay with me going ahead with phase advancing? him?
I am.
Okay, perfect.
Okay? Good luck. Come on, stay with me. Thanks. All right.
We're good till 1 o'clock, right? Well, 12:30.
Yeah.